Channel 964. Attendance in accordance with Chapter 2 of the Acts of 2023, modifying certain requirements of open meeting law and relieving public bodies of certain requirements, including the requirement that public bodies conduct its meeting in public place that is open and physically accessible to the public. This city council hearing is not conducting this remotely, although we're very grateful to be in person. Written comments may be sent to the committee. Apologies for that, everybody. As I was reading, I was like, this does not make sense. Written comments may be sent to the committee email at ccc.go@boston.gov and will be made part of the record and available to all councilors. Public testimony will be taken at the end of this hearing. If you're interested in testifying, please email our Central Staff Liaison, Megan Kavanaugh, at meghan.kavanagh@boston.gov for the link, and your name will be added to the list. You may also testify in person at one of these podiums here in the chamber. Today's hearing is on Docket 1201, Ordinance Preventing Wage Theft in the City of Boston. This matter was sponsored by Councilors Ben Weber, Julia Mejia, and Enrique Pepin, and referred to the committee on August 7th, 2024. Today, I am joined by my colleagues in order of arrival: Council President Louis Jean, Councilor Pepin, Councilor Flynn, Councilor Mejia, Councilor Weber, and Councilor Murphy. I'll now pass it to the lead sponsor and co-sponsors for any opening remarks, and then go through opening remarks for my other council colleagues in order of arrival. For now, I'll pass it over to Councilor Weber for his opening statement.
Thank you, Chair. First, I'd like to acknowledge former Mayor Marty Walsh for signing an executive order in 2014 on wage theft, and the follow-up work done by former Councilor Ricardo Arroyo and Councilor Julia Mejia on wage theft, has definitely informed what we're doing today. As the chair stated, Councilors Mejia and Pepin and I filed this ordinance in August, and I'm grateful to everyone here and the panelists for gathering here. The idea of former Mayor Marty Walsh's executive order and this ordinance is to prevent city contracts and licenses from being awarded to contractors and employers who violate our wage laws. And that doing this will accomplish really two goals. One, will make sure that our workers here in Boston are being paid properly for their work. And two, we will be able to play some role in making sure that that employers who do not pay workers according to the law don't benefit from that by being able to be the low bidder on contracts, or by be able to undermine honest, construction companies, honest employers, honest restaurants, and we make sure that we lead by example and do what we can to stop that. I've circulated a letter to the panelists and everyone else from March 7th, 2024, that was issued by the Mayor's Office of Labor Compliance and Worker Protection. And I believe this kind of letter was sent to a restaurant in Boston for having been found to have violated the wage laws and paid its workers, in arrears. It's sort of a warning that, we see who you are, and please, make sure you correct your practices going forward. I think there's been a few other letters, but going back 10 years, I don't think we've suspended anyone's license or terminated a contract. And I think an ordinance is necessary to make sure that we set up the proper mechanisms so that when employers are violating the law, that their licenses aren't being renewed and they're not being awarded in contracts. And the work already done by the Office of Labor Compliance and Worker Protection, I think you'll hear they did an audit and they found something over 30% of contractors and licensees have wage law violations on their record within the last 5 years. So thanks to their work, highlighted how we need to try to tighten this up and figure out, how we can support workers and honest employers here in Boston. And I look forward to doing that, and thanks to all my colleagues for coming out today.
Thank you, Councilor Weber. Councilor Mejia, and then Councilor Pepe.
Thank you, Chair, and thank you to Councilor Weber for his leadership in this space. It's great to have a lawyer and someone who understands labor law driving this work, so really grateful to your leadership. I think that for me, as we continue to have these conversations, I'm always going to bring the perspective of being an immigrant and someone who's undocumented, and how oftentimes people who are being the most impacted are those who have the least voice and understand the law. And so I'm really happy to have this conversation here as the city. I also think that there's an opportunity for us to, I know we're talking about specifically folks who are doing business with the city of Boston, but I think it's important for us to also understand there are restaurants, there are hospitals, there are other folks who are employing people in the city of Boston that we're not contracting with, and I know we can't oversee that piece of the work, but I think that there is a role that the city can play with some oversight, and I'd love to explore what that would look like. And I think in the interest of just being super mindful, we do have some folks who are here to speak based on their own personal lived experience, and I'll be translating on behalf of Councilor Weber during that testimony. Pero voy a decir algo muy breve en español, porque yo sé que la mayoría de las personas que son impactadas por la conversación que estamos teniendo hoy son personas que son inmigrantes, que no tienen papeles, personas que no saben hablar inglés o no entienden la ley aquí en la ciudad de Boston y no se saben proteger. Y nosotros tenemos una oportunidad aquí tremenda con este proceso que vamos a pasar ahora para asegurarnos que podemos proteger a los empleados y que no sean abusados por las personas que de verdad tienen el poder. Estamos aquí para hablar de eso, y ustedes, las personas que están poniendo atención, den cuenta que aquí estamos trabajando para ustedes.
Thank you, Councilor Mejia. Councilor Pepe.
Thank you, Madam Chair. And both my colleagues started off with such amazing remarks. Both been talking about the importance of holding those employers accountable and making sure that our workers are getting paid. As someone that represents District 5, there's so many city workers that live in my district that depend on that paycheck, on that that week-to-week paycheck, to make sure that they are able to pay their rent, their bills, and it's so important to make sure that they're able to do that, especially in a city where the cost of living is continuously increasing. And it would be a shame to see that something like this continues to happen in the city of Boston. And Councilor Mejia brings up such an important topic, something that I relate to as well, is that a lot of the people that do suffer from wage theft are those that can't defend themselves and that don't know what rights they have. And that's why it's our job to make sure that we have these hearings to be able to fight for them, advocate for them, and make sure that they get their pay. And that's why I'm here. That's why I wanted to be one of the co-sponsors with Councilor Weber and Councilor Mejia to make sure that we bring this to the light. Thank you.
Thank you, Councilor Pepe. Councilor Louise Jen, Flynn, and then Murphy, and we've been joined by Councilor Braden.
Oh, thank you. I'll save most of my comments for when I have questions, but just want to thank the administration and my colleagues for bringing this matter before us. It's really important. Make sure we got to stand with our workers and prevent wage theft. So I look forward to asking further questions. Thank you.
Thank you, Councilor Louise Jen. Councilor Flynn.
Thank you, Madam Chair. And thank you to the panel for being here. This is an issue I've worked on for 7 years, especially on wage theft as it impacts restaurant workers in my district or throughout the city. Working with the Chinese community especially, and the impact wage theft has on immigrant communities. We see it every day, and want to acknowledge Councilor Mejia for her work on this issue, and also want to acknowledge Councilor Weber and thank him and acknowledging Mayor Walsh. I know he's done a lot of great work on this issue also. But in the restaurant industry in my district, especially in Chinatown, in other areas in Cambridge, actually outside of Boston, we do see a lot of immigrant workers being exploited, working hard, working long hours, and maybe they get paid, or maybe they don't get paid. And it's an ongoing problem that we see, but regardless if someone is here legally or not, they deserve dignity and deserve to have their full pay and not be exploited by anybody. Those are issues that are critical to me, and I do believe if we see this happening in restaurants, that the city should be more aggressive in dealing with restaurant owners that continue to exploit workers and their families as well. Thank you.
Thank you, Councilor Flynn. Councilor Murphy.
Thank you. And thank you to the sponsors of this important hearing, to the panel here, and then also the unions. Thank you for being here. I know that it's very important, like Councilor Mejia and Pepin were saying, that many times we're talking about employees who don't feel like they have a voice or that they have anywhere to go. And the whereas that states, the Boston City Council has a duty to protect employees from predatory employer practices like wage theft, I take seriously, like we do have a duty. So hoping that by the end of this or hearing or continued conversations with all of the people who know, the questions I'm hoping to answer are, what tools do we already have on the books? Because many times, lots of things that come through the City Council, we realize, well, we already could do that, but maybe we're not leaning in on things. So I don't want to recreate the wheel, but at the same time, making sure that the tools we have, and like what departments, is it just the licensing department, the Office of Workforce Development, what outside agencies, is it the U.S. Attorney's Office that also could weigh in? So making sure that we're doing everything in our power, strengthening the tools we have, and then talking about, well, do we need to add new tools to our toolbox to make sure we're protecting our workers? So looking forward to the conversation and uplifting those voices. Thank you.
Thank you, Councilor Murphy. Councilor Braden.
Thank you, Madam Chair, and thank you. Good afternoon, everyone, for the panel. Thank you for being here. I'm going to keep my comments brief. I think this is a really, really important issue. It's probably much more pervasive than we appreciate. And workers who work, do an honest day's work, they deserve to be paid in a timely way. They deserve to be able to have all the documentation accounted for so that they can get their benefits accrued over time. And I really feel that there's a really power disparity, and especially as our colleagues, Councillor Flynn has already mentioned, folks who are undocumented or are very, very vulnerable to exploitation, especially in the restaurant industry. So I look forward to the conversation, and I really do thank Councillor Weber and Councillor Mejia for their leadership in this effort to try and improve the situation with regard to wage theft. So thank you.
Thank you, Councilor Braden. I will acknowledge my colleagues as they come in. Very quickly, I'll just say and echo the thanks of gratitude to the makers, Councilor Arroyo, who also put this forward when he was chair, and then also Mayor Marty Walsh for having the foresight to issue this executive order. And then also, I think in 2017, I just want to make sure that I get this right, he had also followed up with establishing payment certification requirements for vendors with city contracts. So I think that that was excellent. Obviously, when we want to codify this, I'm curious to know what mechanisms we have through this ordinance to hold bad actors accountable. And the way in which Councilor Weber had articulated it in the whereases, where it basically is a race to the bottom, where we're ripening the conditions for certain folks paying the lowest possible rate to not pay their workers or to have any sort of nefarious practices. So this is necessary. I'm just curious to understand how it might actually work operationally. So with that, I will pass it over to the administration panel. First, I'll introduce them. We have Trin Nguyen, who's the chief of the Worker Empowerment Cabinet. Jody Sugarman-Rosen, who's the Deputy Chief of Worker Empowerment within the Office of Labor Compliance and Worker Protections, and also Lou Mandarini, who is the Senior Advisor for Labor within the Mayor's Office. And Lou might be called away to address an urgent matter, so we will forgive him for that, but also provide some grace as he navigates that situation. Following that, we will have questions and comments from my colleagues. We'll also go to a union and advocates panel, in addition to discussion, and then public testimony. So with that, I'll pass it to the administration. It's up to your discretion on who wants to go first, but the floor is yours. Thank you for being here.
Thank you, councilors. Can everyone hear me?
Yes.
Great, thank you. And thank you, all the councilors for their remarks and for being present for such an important topic and work ahead of us. Want to specifically thank Councilor Mejia, who's been working with our administration and our office for the last 3 or 4 years on this topic, and then recently Councilor Weber, who's been on the boots on the ground for working hand in hand with our office. So thank you, Councilor. My name is Trin Nguyen, and I have the pleasure and an honor to serve Mayor Wu's Chief of Worker Empowerment and the Cabinet. And while wage theft is part of the labor compliance for our Worker Empowerment Cabinet, we see this as a collective effort through all the partnerships with various departments. So it's not just the Office of Worker Empowerment that is leading it. The third reason why, obviously, even if I didn't have this personal experience, I think this should be the forefront of the issue, is that my family came here as refugees and immigrants in the early 1980s, and they were victims of wage theft. They couldn't speak English. They worked as dishwashers for the last 40 years of their acculturation process here in the U.S. So this is not only really, really important and front and center, but it hits the heart as well. And I know that each and every single one of you in this room and all of you council members, that you have somewhat of an impact on this on a personal level as well. So I just want to give you a brief background of the wage theft issues in the city of Boston. And these are just kind of overview data points that we tried to keep as succinct as possible. And we went through various notes to make sure that we use your time wisely and only pinpoint relevant data. If you have any questions, feel free to reach out to us at any time.
Trin, really quickly, I'm just going to ask that you say next slide so that our staff can follow along with you.
Thank you,
so much.
Councilor. So I'm still on the first slide, sorry. So from 2019 to 2023, the Massachusetts Attorney General's Office, which we work very, very closely with, their Fair Labor Division and the U.S. Department of Labor's Wage and Our division, which is also referred to USDOL, which we work on a constant weekly basis of collaboration, had 275 cases of wage theft in the city of Boston alone, and that's only ones that are documented. 30% of the Boston wage theft violations from the AGO and DOL over the last 5 years were with companies that had a City of Boston license, and 4% with companies that had a City of Boston address and contract larger than 25,000. Shows how we can make a difference if we all come together. So in total, the Massachusetts AGO and U.S. Department of Labor cases resulted in $9.6 million in fines recovered for wages for workers, and $4.3 million from employers and contracts for or licenses in the city of Boston. And Mayor Wu and the administration have focused that in terms of addressing it. There's so much more that we can do. There's also underreported numbers from undocumented immigrants that we're not seeing here. So the magnitude of this issue is unfortunately over 100 to 200% fold. So the problem is very, very urgent. I'll stop there and let my colleague, either Lou or Jody, proceed with that.
Okay, so I'd go for the next slide, which is slide 2. By way of introduction, I'm Lou Mandarini. I'm a senior advisor for labor policy to Mayor Wu. I have been involved in drafting a lot of these ordinances around the Commonwealth, and was involved with the mayor when she was a councilor back when. There's a little bit of unfinished business here because a wage theft ordinance was actually one of the first things she filed when she got on the council. So this is a nice decade to complete the task, but here we are. I want to come at it from two angles that are not in the presentation, and then I'll pick up the presentation. But I think there are two things at the outset that I want to talk about that are important reasons for pursuing this, that aren't necessarily going to be ones that are uppermost in the minds of folks. So according to the last statistic I saw, 14% of workers in Massachusetts belong to labor organizations. They belong to unions, which means the vast majority don't. And I think if you don't have a union and you don't have ready access to a worker center, which represents an awful lot of folks in the city, particularly I think with sort of new Bostonian populations, how do you redress the fact that you haven't been paid properly, you haven't been paid completely, you haven't been paid on time? Do you know where to go? Who do you go to? Who do you talk to? How do you vindicate your rights? So a huge part of this is education and making sure that folks know what their rights are, and where to go to vindicate them, and how to redress them. It's not an easy process in Massachusetts. As Councilor Weber, who spent some quality time in Ashburton Place, I think will tell you, it's not easy to do it if you don't know what you're doing or you don't have somebody to take your hand on how to do it. So I think that education is one part of it, and the fact that you don't have a lot of people out there, or you have a lot of people who don't necessarily have someone to stand up for them. And then I think the other piece of it that's an important piece to talk about, and I'm sure our friends from the labor community, the iron workers and the carpenters will tell you about it, because they've got signatory contractors who pay a competitive wage, pay health insurance, pay a pension, pay an annuity, and they do right by guaranteeing that their workers can advance into the middle class and support themselves and their families. But the problem at the end of the day is when other people have built into their business model cheating and cutting corners and undercutting those folks, it makes it hard for them to compete, and it makes it hard for them to be the pillars of the construction industry, the restaurant industry, the hotel industry. So those businesses that do right by their workers and pay people fully and on time and competitive wages, you all know them. I mean, they are the fabric of every neighborhood in this city. And this ordinance, in addition to advocating for workers, is about protecting those businesses that do the right thing. So that's a piece of it that I think is important to frame from the jump. So with that, I would point out more in the presentation. The places where we see the greatest violations, as Councillor Flynn pointed out, restaurant industry and the construction industry. 157 cases, 57% of the cases that Trin referred to, Chief Nguyen referred to, came in restaurants. 25 cases were in construction. One of the construction cases, the entity had a contract with the city of Boston. These numbers don't take into account a huge number of violations never reported, complaints never investigated, private right of actions not pursued. About 70% of complaints made to the Massachusetts Attorney General's office result in private right of action letters. What happens after that? Sometimes these things get settled. Sometimes you can find a lawyer to represent you. Sometimes you can find a worker center to help you, but often you can't. So this is why the education piece of this is vital. It's very, very important. It's a huge part of what we have started with the cabinet that we created at the outset of the administration. And then the final piece of this, if we can move on to the next slide, which I think is the fourth slide. One more. So just to review, so we have been seeking, and obviously the council, to pass a wage theft ordinance that's going to codify a lot of what existed in the executive order that Mayor Walsh promulgated in 2014. So just to review what that executive order provides the way for. So it requires city vendors to certify to the city their compliance with federal and state wage law, and to report violations and provide a wage bond. Prohibits city departments from contracting with debarred vendors for the period of their debarment. It amends the standard contract general conditions language for compliance with law and public policy violations of Chapter 149, Chapter 151, the FLSA, within 3 years prior to the contract. It ensures potential and current recipients of licenses issued under GL 138 and Chapter 140 to comply with applicable wage laws. And the Boston Licensing Board may consider whether a current or potential licensee has been subject to federal or state criminal or civil judgment, administrative citation, order or final administrative determination resulting from a violation of 149, 151, or the FLSA, in determining whether to issue, reissue, modify, suspend, or revoke a license. So that's where we stand now in terms of the legal authority that we have and that we have been working under for 2 years since the cabinet was created, 2.5 years. And with that, I'll cede the floor to Deputy Chief Jody.
Thanks, Lou. Thank you so much for the opportunity to present today. My name is Jody Sugarman-Brozan. I'm a Deputy Chief in the Worker Empowerment Cabinet and lead the Office of Labor Compliance and Worker Protection. So my job today, over the next couple minutes, is to tell you a little bit about how enforcement of the wage theft executive order actually works so that you can understand the departments involved are listed on this slide: labor compliance, procurement, auditing, other contracting departments, and the licensing board. And a little bit, if you go to the next slide, the way that we enforce the current executive order is in a couple of different categories: pre-award of contracts, during the time that people hold a contract, and then post-award. So pre-award, bidders have to complete a wage theft prevention form, it's called the CM-16, with their bid and or proposal disclosing or certified compliance with the executive order. And this is where auditing department comes in. The auditing department is the one who creates the forms and the standard conditions, but it is the procurement team that creates the forms that are used as part of that process. When someone has an award, those standard contract terms and conditions address disclosure of future violations and debarment, which has happened, and the city can ask, if it wants to, for wage bonds if a contractor discloses previous wage violations, and it happens at that point. Post-award, any contractor or vendor that discloses a wage theft violation as part of those forms has to provide a monthly certified payroll record to the awarding department. And if the prospective vendor is currently debarred, a bid is rejected outright. If a vendor is debarred during the contract term, the city may terminate the contract immediately. And if you go to the next slide, the Office of Wage Theft, Office of Labor Compliance and Worker Protections, which we shorthand to OLCWP, shares wage theft data regularly with the licensing board and sends letters to company with willful and repeat wage theft violations. And Councilor Weber shared one of those letters. When we find out about a company that has a repeat willful violation, we send, and they hold a license with the City of Boston, we send them a letter to let them know that we've seen this, and we copy the licensing board so they know as well that the particular company that holds a license has a serious willful or repeat violation. Starting with this 24-25 year, the licensing board is also going to do something similar to the procurement team, and they're going to start requesting disclosure of wage theft violations in advance as part of the licensing application. If you move to the next slide. The Office of Labor Compliance and Worker Protections has really tried to help support enforcement of the executive order since we came into existence a couple of years ago. So one of the things that we do is work really closely with the Attorney General's office. Right on our website, we receive complaints for wage theft. We refer those cases to the Massachusetts Attorney General's Fair Labor Division. So in the FY24, we referred 59 cases. 35 resulted in private right of action letters, meaning they were given an opportunity to pursue on their own a wage theft case. 10 investigations are currently open. 3 employers were cited. 1 was an informal investigation, and 10 of those were closed. Our Senior Program Manager for Living Wage and Wage Theft, Monique Mitchell, who couldn't be here today, but has done the lion's share of work tracking wage theft data and cross-referencing it with licenses and contracts, and that's something new. Again, the letters to repeat or willful, those who have a repeat or willful wage theft violation. We also, when this is part of our implementation of the Boston Resident Jobs Policy, a lot of wage theft comes in the form of not paying people properly the wages that they're due, and that's especially true when it comes to construction and prevailing wage. So we've really upped our game with regards to monitoring for prevailing wage. We now have a construction monitor at the Boston Resident Jobs Policy who's monitoring, not only collecting the certified payroll records, but cross-checking those against the bid sheets that are provided to make sure that our construction work is not leading to wage theft. And we already, and this is part of the new ordinance, but we had already started working with DoIT, the IT folks here, to create a database of wage theft violations to the extent that is public information that licensing and contracting staff can use to cross-reference, because we know that oftentimes disclosure may not actually be the best way to collect information on these wage theft violations. And then next slide. This has been a really important piece. As we said, about 70% of the cases of wage theft or complaints for wage theft that go to the Attorney General end up in private right of action, which means that those are folks who are pursuing those cases on their own. And many cases, many people don't know that they have a right to come forward with wage theft complaints. And I think it's really important to say that you have the right to come forward with a wage theft complaint, whether or not you are documented. You have the right to be paid for the hours you work. Documentation is irrelevant. So it's really important that we move forward with education and outreach, and that's been a big part of our effort over the last couple of years. Last year, we partnered with 4 worker centers to hold 5 Know Your Rights workshops and resource fairs in 5 different neighborhoods across the city with translation in 7 languages, attended by about 200 workers. And this year, we are practically doubling. We're doing 5 resource clinics, 8 workers' rights webinars, and partnering with worker centers to provide multilingual Know Your Rights training in languages that people understand. So we know that the ability for the city to take action on those cases that actually result in a violation with the Attorney General's office and the Department of Labor are just a handful, as Chief Nguyen has said, and we really want to make sure we have strategies to work with all workers. And that's the end of our slides, and we can answer questions that you have about. We have reviewed the ordinance and are looking closely at the additional disclosures and certifications and other things that are required by the ordinance to assess our capacity and think about how we would move forward, and we're working on that now.
Thank you so much for your presentation. It's very thorough, and just so my colleagues know, you do have a copy of this presentation in your inboxes through the folder that was sent by Megan Kavanaugh. So now we'll go to questions and comments from my colleagues. I'll say 6 minutes for each. So I'll go to the lead sponsor, Councilor Weber, Mejia, Pepin, Louis-Jean, Flynn, Murphy, and then Braden. Go ahead.
Hi. So I just wanted to start with something in the presentation, and we were just talking about private rights of action. And to me, that brings up an issue of, what is going to trigger our actions, and I think under what we've been doing is if there's a wage theft order from the Attorney General's office or the U.S. Department of Labor, that should alert us. But okay, so what happened for my colleagues, if you file a complaint with the Attorney General's office, and I worked in the Fair Labor Division, 70% of the complaints, you get what's called a PRA, private right of action, saying, sorry, either we don't have the resources or you've come with private representation, and before you can file a lawsuit in court, you have to go to the Attorney General's office to get this private right of action. So in those cases, let's say they're all being represented by attorneys, and they go and they win their case or something, that wouldn't trigger, 70% of those cases wouldn't trigger any action under the current rules. So I don't know, Attorney Mandarini, if you have any thoughts about whether we should just be limiting this to the, wage theft orders, or we should be looking to expand, what triggers some action here?
Well, I think there's a lot of hard questions we have to answer in the process of doing this, and you've touched on one of the hardest. What constitutes a final adjudication? What constitutes the thing that triggers, responsibility under a wage theft ordinance? So, I think it would be difficult to peg it to the private right of action as the thing that, constitutes a violation. I think that'd be hard. But at the same time, too, when the Attorney General's office resolves one of these things directly, it's one of the few cases that they keep, does that constitute a final adjudication? Is it a consent decree with the Department of Labor? I mean, I think that's the work we have to do, is what fires the starting gun?
Yeah, we can certainly, the most egregious are orders to pay wages that have not been paid. That should be just reserved for a certain level 1 offenders or whatever. And then where there's a wage theft order and they've paid everything, I think we can treat that slightly differently. But, I was thinking and a lot of people, most of the cases get litigated privately, if at all. If there's a summary judgment ruling, some ruling by a court, I don't know, and then that gets to the database, which we can get to in a second. But yeah, no, I agree. It has to be some sort of due process. You don't want, just because somebody filed a complaint, then that a contractor can't get a contract here. I don't think that's a good idea or a good policy.
I'd add one more thing. I think the other central challenge here, as everything involving Massachusetts and municipal power, is we also can't do enforcement. So we're foreclosed, by the Wage Act and a lot of, places from doing direct enforcement. So, at the end of the day, what triggers, again, one question is what fires the starting gun for a violation of the ordinance? And then secondly, what can we do short of enforcement to actually vindicate the rights of people who want to use the wage theft ordinance on the other side of it? Yeah. If the city can't enforce directly, how do we get people to worker centers? Is it simply education? Is it simply procurement? Is it licensing? These are all the questions we have to answer.
Yeah, and so I guess, what do you think in terms of taking an action to deny someone's bid for a contract? Can we do that?
So in other words, could our procurement in whatever capacity it's implicated, take into consideration some wage theft violation in denying someone a city contract?
Correct.
Yes, I think we could do that.
Okay.
I think that is the city acting as a market participant. And I think we're probably on our firmest ground in acting in that setting.
Well, let me just go through a couple more things while we have you here. So suspending an existing contract if somebody is issued a wage theft order.
So that is to say, someone has a contract. I just want to repeat it back to you to make sure we're. So somebody has won a contract that we've bid out. In the course of their performance of that contract, a wage theft violation. Now, does the wage theft violation, because it's just the facts matter, does the wage theft violation happen in the course of doing the thing that they contracted for with the city, or is it this person also runs a pizzeria in Roslindale and they do?
I answer your question with a question, and just if it's important, if that's an important fact.
My sense of it would be, if we're acting in the performance of the contract for the city, we're probably on firmer ground than attaching something unrelated to it that just happens to be the same entity that won a contract. But I think that's certainly worthy of conversation.
And what about denying someone? I guess, I don't know if, in terms of the licenses that we issue that would be impacted, can you, identify those licenses? And then the question is, can we deny someone a license if they have, in your understanding,
Well, I'm going to say that I think one of the great skills in life is to know what you don't know. and to acknowledge it. So I would leave the licensing question and I imagine we're headed for a working session on this with our procurement and our licensing folks. So rather than write a check I can't cash, I would wait for that to answer because the licensing questions are the thorniest, and frankly, we don't have consensus in the administration on what we can and can't do.
Okay, well, and just for in terms of policy, Jody and Trin, what do you think about targeting that? You already issue letters on that. Is it important for us to look at that?
I think we've shared we target the letters specifically for those who have willful or repeat violations, because we know sometimes these wage theft cases are simply the employer not knowing their responsibilities, which we need education on that side as well. And we share the information, and I think we have to balance it really closely. We don't necessarily want to close down a restaurant that provides people jobs that they rely on. We want people to get the wages that they're due. So we want to use that as a way, and our licensing is a way to leverage that to the extent we can. And the letters really are about letting them know that we have their eye on them, that we could modify, according to the executive order, although there is, we're not quite sure exactly where we have the line, modifying, suspending, and revoking licenses is in the current executive order.
Okay, yeah, I don't, did you, and then just lastly, again, back to Attorney Mandarini, so the ordinance gets to, contracts, licenses, and it also addresses TIF, tax incentive financing. Do you think that we have the power to impact those based on wage theft?
I think we have the power to. I think the question of whether and how we would do it, I think is really the main question. I would point to two other things that I think are really quite important in the ordinance as drafted, is the education aspect of it and the database. Because I think another piece of this that's really important is shaping consumer behavior. I think if people understand that Stash Pizzeria conducts its affairs the way it does and treats its employees the way it does, one of the most important things we can do is help shape consumer behavior to know what businesses in our city, how they're conducting their affairs and how they're treating their employees. So those are two pieces of it that firmly fit within what we can do. So I just highlight those as an appendage to.
Okay, and then just on the database, so that's in the ordinance, we would have a database of these violations, which I guess my question is for Jody. Do we have an adequate database now? What would we need to have one that you think would get the sort of mission accomplished here? And lastly, who do you think should maintain, update, and sort of have sort of control over that?
Great. Those are all the questions we're trying to answer. Our office, the Office of Labor Compliance and Worker Protections, has been working with DoIT to define what that would look like, and basically taking public data that's available from the Attorney General's office and the Department of Labor combined into one place. As you know, they each provide data differently. The way that they find violations is differently, so we're having to work through that. And we also want to make sure that we're making the database actionable. In other words, if someone for procurement were to use it and brings up find that somebody who is seeking a contract has a violation, that it says these are the steps you must take, a wage bond, a disclosure, really being actionable. But we've been working on that. We want it to start internally so that we can use it, but our goal, similar to the ordinance, is to have a public-facing tool, because the data is public-facing, so it would just allow us to put it in a way that the public can utilize it more. But first we need to work with the IT folks who know how to put these things together and make it happen. Our senior program manager for living wage and wage theft has been the lead on that, and is really the one who also has done the number crunching, data collection, cross-referencing against contracts and licensing.
Okay, and do you think your office can, would you need extra staff to do this, or do you think that you'll be able to manage this with the
I
current
think
staffing levels?
we're definitely looking at the capacity questions that the ordinance provides right now, and we'll be able to answer that more, but.
I mean, one question I was thinking about was whether, honestly, labor, the unions, which often police, like they file bid protests and things like that to make sure our bidding processes are followed, like whether they might be able to lend help with maintaining the database. But I don't know, Attorney Mandarini, did you have any thoughts about that?
Yeah, I mean, I think this is a variation of the first question that we talked about, which is what constitutes a final adjudication for purposes of inclusion in the database. So again, what fires the starting gun for a violation? Because, you have to have something that is unimpeachably a violation, that everyone would agree is a violation. So what is it? But to your direct point, I mean, can our labor partners and worker centers and that kind of thing be a source of information that could be included in the database? Absolutely.
Councilor Weber, as lead sponsor, you've gone over your time. However, I'm going to give you one
Chair.
more. And then we're going to go to the other lead sponsors.
Okay, I'm sorry. And just there's a section of the ordinance where we talk about what would trigger, and obviously failure to pay wages, deductions, failure to pay tips, misclassification, of workers as independent contractors. Do you think we should we look at like failure to provide workers' comp or unemployment insurance, or I don't know whether sort of these non-wage but workplace abuses should be included?
To the extent that folks are debarred for failure to provide workers' comp, it's already included in there.
Yeah, I mean, I think it's a difficult question because I think this also gets to the sort of the balance of power between the Commonwealth and a municipality. If there are remedial schemes in other statutes to guard against violations of those statutes, which there is in workers' comp, which there is in unemployment, that kind of a situation, I don't know whether we necessarily have the power to do it. So I think it's something we have to think about.
Okay, thank you, Chair.
Yeah. We'll still go back, understanding that you have more questions. I'll go to Councilor Mejia and then Councilor Pepin.
Thank you, Madam Chair, and thank you, Councilor Weber, for all of your great questions. So I would just like to, just for those folks who are tuning in and trying to understand everything that we're talking about here. So wage theft includes unpaid overtime, right? Being paid below the minimum wage, right? Stolen tips, working without breaks, among other violations. Now, being paid below the minimum wage, let's just focus a little bit on this. If you work at a restaurant or somewhere and your employer asks you to come in at 6 o'clock in the morning and you work until 11 o'clock at night and you do that 5 to 7 days a week, you are already working more than a week's worth of salary, but you're getting paid the same. If you are undocumented and you don't know what your rights are, then who do you report that to?
I know a lot of worker centers work very closely with undocumented folks to help access their legal rights and make a complaint. Certainly, undocumented people have the exact same rights in terms of being paid wages that they are due, workers' comp, health and safety, OSHA protections, those all are your rights regardless of documentation. So it's really about making sure people know they have the rights and have access to that. That's what we're trying to achieve with our worker resource fairs and our Know Your Rights education. That's why we partner with worker centers who have language capacity that we don't, to be able to work with folks to help them understand that.
Because I think what happens, at least what I've seen, is that there is a disconnect in terms of who is responsible, right? So the worker, it's great for them to know that this exists, but who's responsible ultimately, right? So I'm just curious about what role, if any, will the city play in doing enforcement work?
Sorry. I mean, I can go to enforcement. I think we don't have the direct enforcement. We don't have the power to do. To answer your question directly, I think the places that worker facing that circumstance could go are United States Department of Labor. They could go to the Attorney General's office. They could go to a union. They could go to a worker center. Those are all places that would help people vindicate their rights. I think what the thrust of this and what makes the most sense in what we're doing is that city government is the form of government that's closest to the ground. Mm-hmm. We are, so in other words, if you had the ability to go into office hours in Roslindale or office hours in South Boston and report some violation to the city, that's a lot easier than going to Ashburton Place or going to the U.S. Department of Labor or other places that you may not know exist. So I think one of the things that's really key to what we're doing here is reporting the violations to the level of government that is closest to people. Mm-hmm. I think that's a very important part of what we're doing here. So that doesn't really exist now, and this will help it exist.
Great. Thank you. And I'm curious, Trin, if you don't mind, I really do appreciate your lived experience and how you were able to really help us understand your journey, and it really provides more context in terms of what we're trying to do here today. What role would you say the city, because I think it was either Jody or you, I'm not sure who said it, but in terms of from accountability, it just feels like I'm not really convinced at this point that even with this ordinance, the enforcement part will really be something that the city can actually do on a regular basis, because the onus again goes on the person who's being violated, right? Like, help me from a kind of like infrastructure standpoint. How will you be able to set this up in terms of implementation? Would you be doing, monthly raids or showing up at restaurants? Like, help me understand the how in terms of implementation.
I appreciate that question. I think to respect people's time, I'm going to be as very brief as possible. So first is that on a client scenario, meaning the person being violated or being a victim of wage theft, we have to understand that the challenges with that resident or that person interfacing with a government entity would be very low. So that is why I think education, they're not going to come to our office. They just won't. But I think trying to get to partners, worker centers, influencers, hotspots in the community to get the word out in various languages that our partners are not part of the government sends a very amicable message to that community who's being impacted by it. So that trust is important, and unfortunately, government is probably not that trust-facing figure at this moment. So we do have a more intentional strategy, and we've looked at various nodes, interviews, the focus groups to come up with a community strategy. In terms of the back end and compliance, is there a way in which the city of Boston can send a message and can do, by practicing, sending a clear message that we will not do business with a vendor or an entity that violates X, Y, and Z? Absolutely. Do we have a cohesive strategy around that? We need to work on that, as Lou articulated. Do we have capacity to do that? Absolutely not. I mean, I have been through the rigmarole where ordinances of comprehensive magnitude, thoughtfulness have been passed from plans to plans, but if you don't have an infrastructure and intention of various capacity to do X, Y, and Z, those ordinances and plans will just sit there.
Right.
So we've seen that throughout 2014 when Mayor Walsh had declared the executive ordinances. We have seen and worked with various departments. Now, we can start with two major departments that have levers. So it could be the licensing board for restaurants, and it could go back to what Lou is talking about, is that maybe we have to figure out a legal component to revoke those licenses. Mm-hmm. That's a different question. But we can make calls and say, hey, we've seen this on your record. Would you come and talk to us about why you're renewing these licenses and this application, and why your M16 form says X and Y and Z? And our continued conversations and meetings with the AGO office can say, oh, are there things we should hear about, learn about, and keep those lines of communication open with the AG. Since we don't have legal authority, we should keep those lines open. The second jurisdiction that I think we could have conversations on a deeper compliance partnership is perhaps the zoning board, the ZBA, and perhaps if they were pulling the occupancy license or the certification towards the end, have they filled out their M16 form, for example? And if they did, if there were these violations, could we call them up? That's not to say that we will stop or slow their certification, but it would put in a process for deliberation that could send a clear message to the public that we take this very seriously.
Right.
So those are the examples in which we can go through the matrix to see what Lou is talking about, which is the legal framework, what Jody's talking about, which is the education piece, and finally the gap piece that I'm trying to articulate, which is where are those gray areas in which we can work together to make sure that we can't have 100%, but 60 or 70%, that message is clear in the city of Boston.
Thank you for that. And that was such a great answer to the question in terms of just the how. And I really do appreciate you walking us through, because I said this in my earlier hearing, is that policymaking is very nuanced, right? And it is also a very privileged process, right? There are people who have a lot of experience in government and know the ins and outs, and then there are a lot of people who are just learning it. So I think it's very important for us as we continue to have these conversations to understand that everybody's coming in from their own very different lived experience and perspective. So I really do appreciate the time that you took to break it down like that. So going back to the restaurant, I'm going to go back to the restaurant because those things are a little bit, because we have a lot of other things in place around construction, and I know we've been doing a lot of work with the Boston Jobs Residency, like ordinance that we already have established. So there are a lot of already things in place and mechanisms. And I'm just curious in terms of just from the restaurant's perspective, would it be something, Trin, I'm going back to you, because what good is an ordinance unless it has the legs to stand on? I'm just curious in terms of the renewal, right? Let's just say, for instance, like when they have to get a permit or they have to do something over, would this be the place where we would review, see the dashboard maybe, Jody, like how many complaints have we gotten from the people who work there for wage theft or whatever other violations, and then based on a metrics, we can say you are a repeat offender, you are, in danger of not being able to be renewed. What does that look like? What's the mechanism?
I would love to answer that question. I just don't think I have the answer to those questions. And Lou and Jody, I think we're still going through an internal process in which we can have a consensus of where the sequence of supply chain would happen. And it would have to happen from the person in the entry level coming into the application. They have to understand what the M16 form is about, and then it goes up the chain to have a process in place to flag that. Internally, I think we're working on that. I don't think we have an answer for that. And I also defer to the licensing department and board to answer that.
Thank you.
One thing I would add, I think the question about what you can do with a license is an open question, and it's one we're probably going to have to solve in the working session. But one thing that's been effective in other places, and San Francisco does it pretty well, is cross-train inspectors. Cross-train inspectors, construction inspectors or health inspectors, to be on the lookout for obvious labor law violations or to see what's going on. This is sort of like what happened with Stash's Pizzeria. Yeah. If there's some bad behavior going on with human trafficking, there's probably a lot of other stuff going on too. So when you go out to do a health inspection, are you also looking around at who's the workforce? Are you hearing things? Are you looking at things? And can you bring that information back so that it's actionable, with the folks in the cabinet here and what to do with it? So I think that's one way to get at it, your question, and it's something that's been effective in San Francisco. I think Chicago does that too.
Thank you.
And we did train about 100 inspectors last winter on how to identify labor trafficking, and that was a successful, we'll do it every year in January to ensure people have that skills. But that's one piece. Labor trafficking is only one piece of the puzzle here.
Yeah, and I'll just end with, because I know, and I do appreciate the extra time that you've given me, Madam Chair, that Councillor Flynn had talked about in his district and a lot of the violations that happen for hotel workers, restaurant workers, and I'm always looking for the list of who are the bad actors, right? And I know that whenever we have our Boston Jobs residency, we kind of already know who are those folks who are not in compliance with the city of Boston. And I just think that as we continue to have these conversations, it's not about just shaming people, but if we had a way of keeping a list of who those folks are, I think that the education piece is very important. And I'm not sure, I think it was Lou, or maybe it was another hearing, but you don't know what you don't know sometimes. You don't know what you don't know. It was Lou, right? I feel like I've been here all day today. But I think that is really key to this conversation, is because we're operating under the assumption that everybody knows what the laws are, and we're operating under the assumption that everyone's going to have goodwill. And I think those assumptions oftentimes really show up in this conversation. So I just want to note that, and I want to thank Councillor Flynn for recognizing the fact that there are a lot of folks who are being taken advantage in so many different spaces and places, and it's not just labor, because a lot of these restaurants and other spaces don't have unions. That's the other piece, right? So that when we're talking about protecting our workforce, a lot of these spaces don't have real formal structures to be protected. So that is one thing that I think gives us an opportunity to explore what education looks like. So I will yield the rest of my time. Thank you.
This is a really fascinating conversation. Just want to thank my colleagues for their amazing questions. Councillor Pepin, and then Councillor Flynn.
Thank you, Madam Chair. Just first, kind of want to thank my colleague, Councillor Mejia, for always looking at things from a different perspective, and usually the perspective of the employee. I think that's just give her credit for that, so thank you for that. Taking a look at this letter of this example that we got, and first of all, shout out to one of my District 5 owns, Mimi Turkinitz, for the work that she does over at the Office of Labor Compliance and Worker Protections. It's good to see her here. The first thing that comes into my mind is, when the employer gets this letter, does the employee get a letter as well, letting them know that their employer has been notified? And if so, does it come, can it come with resources that exist for them? Because what's the point of, let's say I'm the worker, my employer's getting the letter. I don't know if they got a letter or not. And I don't know, one of my follow-up questions to that is, as an employee, is there backlash for me reporting my employer? And what protections do I have when I'm trying to advocate for myself, but maybe my employer isn't following through?
Currently, that's a great idea. We do not share the letter with employers. We don't have employees. We don't necessarily have that list, but I think sharing that along with resources is a great idea. And also sharing resources about the fact that retaliation against workers for coming forward is completely illegal, and what you do if you are retaliated against as well. These go only to the restaurant owners or managers per whatever information we have in the actual violations. But yeah, that's a great idea that I will definitely take note of. Thank you.
No, of course, yeah, because I'm just thinking about, I don't even know, how much time does an employer have to respond to this or to act upon it?
There's no response required. It's the response. We share it with the licensing board to let them know as well that these violations have come up, so that they can then use that as they receive whatever applications for renewal. If they want to ask specific questions, hold a hearing, they have that information, but we don't require any follow-up. The letter is just, we are watching, we know that these violations have happened, reach out if you have any questions, and just a reminder, this is the law.
I know that Lou mentioned that we can't enforce, the city cannot enforce when it comes to this, but can there be something that says you have to respond to this letter, acknowledging that you will take the appropriate steps? Because I think it was Councilor Mejia that said it, that a lot of people don't act in good faith. And at least I would think we can get a response from them.
Yeah, I mean, I think it's an interesting question. I mean, while we can do direct enforcement, I think we can do a lot of things that tiptoe right up to the precipice of enforcement. So we find a bunch of violations, can we collate them and send them to the Attorney General's office as a package and then follow up on what they do? Can we do that with the Department of Labor? Can we set up working groups or task forces that, work with the Attorney General's office or the Department of Labor? I think there's a lot of things we can do to spur enforcement, even if we can't necessarily do enforcement ourselves.
Right.
So I think that's a fair answer to your question.
I think if you look at the M16 form, when we had designed it, obviously we had a wish list of the M16 form, and then over time it got amended and different conversations had it. I don't remember exactly where it is now, but it asks those kind of backgrounds and questions. And then if we had strategically designed a database that has those copies of those, we can cross-reference them, as Jody mentioned, in terms of, what our staff does. But again, it goes to the issue of compliance resources. And you have one staff working on 2 or 3 different ordinances, cross-referencing various databases, which we don't have, by the way, yet, because we're designing it. And obviously, you all are very smart. You know how much a database would cost, and then a sophisticated one, then you roll it out, and then you get other agencies involved and their buy-in. It is a process to take seriously, and right now, it's all by word of mouth, and if I pick up the phone and ask Jody and Lou tags me, then we address it. But it shouldn't be based on, who's calling who, but rather there is a finite infrastructure for accountability that flags that. We're very sophisticated in IT in the city, in fact, maybe the world, but something like this just really takes me aback on why we're not so sophisticated in.
Right, and it also makes me think about if we had that database and we were able to share with different departments, bringing it back to the licensing department. Let's say one of these restaurants that are committing wage theft, and they're applying for a new liquor license. Why would we give them a liquor license when they're not following through with paying their employees correctly? So I think that it is important to cross-share that information with the different departments in the city. Which I have one more question about. If there is a business or an employer that is committing wage theft, is there a tax penalty for them?
No, that's not something that exists now.
Okay.
There are various ways to engage in enforcement, but I'm not aware of a tax penalty for it.
And I ask that because if they're
Well, actually, you know what? I shouldn't say that. If they're not doing proper withholdings in that kind of a situation, there can be.
That's why I'm asking, because
Yeah.
if they're not reporting correctly, the city of Boston is missing out on revenue in terms of tax. So I'm thinking about how do we enforce that once it's all figured out at the court.
Yeah. Certainly the IRS can pursue them, and
Right.
often does, and the State Department of Revenue.
And there are many cases, I'll say, in which workers successfully go themselves with a lawyer, with the support of a union or a worker center, and get a finding that they're owed wages, and then the employer just ignores it. And in those cases, I think we can have particular leverage, because when we have a business that's been had shown to have wage theft cases, but has paid their fines, their workers, and now are employing workers that we don't want to lose their jobs, we can keep an eye on them. We can make sure they're continuing to follow through. If there's a restaurant who's had a finding of wage theft but has failed to pay their workers, that's a case where maybe we can look look at what powers we might have in licensing to have them pay their workers the wages due before we move forward. Again, depending upon our ability and our whatever licensing, what we have in terms of power with regards to the licensing process.
That's perfect. And, before I conclude, I think that my overall message to you all and to everyone in the chamber is that if the employer is getting an information, let's make sure the employee gets the same information so that they know what's happening with follow through. But with that, I'd like to yield back the rest of my time and thank you for being here. I look forward to hearing from the rest of my colleagues.
Thank you, Councilor Pepin, and I apologize. I made an error when I was announcing who was next. It's Councilor Louis-Jean, Flynn, and then Murphy.
Thank you, Madam Chair, and thank you to the makers for bringing us this matter before us. Hopefully we can bring it across the finish line. I want to thank Lou for your framing about why this is important, which I thought was really helpful. Employers are baking into their bottom line theft, and that makes people who are trying to do the right thing, trying to hire a union, trying to make sure that people are getting paid a living wage, it makes it more expensive for them to do the right thing. And I think it's that important framing that really explains why this is important, in addition to making sure that people aren't experiencing theft in the second most expensive city to live. Largest case of wage theft that we see is misclassification. Is that right? Or does it depend?
I think it's a question for DOL and Attorney General's office, but misclassification certainly is right up there, which is why the Attorney General's office and Fair Labor Division takes it so seriously. I think it's a wide range, not being paid overtime, being paid under minimum wage, those all are in there as well. New earned paid sick time law, that's now part as well, can be considered wage theft.
I think the failure to pay timely and complete wages, I imagine, is a meta category that's enormous. Whether it's larger than misclassification, I don't know. But.
Okay. Council Weber, I believe, offered an idea that folks who violate this be prevented from actually having contracts with the city. And I would like us to explore that in this conversation, but it's also something that we've brought up repeatedly when we're talking about the Boston residents' job policy, and think about how do we get more serious with what it looks like to be compliant with the BRJP, to use carrots and sticks. And so just trying to think about how we're thinking about that, like, is that something that we're going to be able to do? Are we marching towards that? Both in this scenario and in BRJP, obviously, which also Councilor Weber has been shepherding this term.
Yeah, I think the first step is the database so that it can be very clear for our contracting and procurement staff. Obviously, disclosure takes it to a certain degree, but making sure that people can double check that disclosure matches what is the actual reality is really important. I think for the Boston resident jobs policy, the first step we're taking there is the new dashboard, which we've shared with you all. I'm looking forward to sharing that at our hearing in October, which allows people to search by contractor to be able to see the contractor's history with the Boston resident jobs policy compliance. So that can be used either through procurement, or if you're a general contractor, when choosing those subcontractors, you'll be able to see who's had a better data, better numbers with regards to the Boston resident jobs policy. So the first step is understanding and data collection, I think, and I think that's why the database is so important for us here as well.
Thank you. Yeah, and having the database to see is going to be great, and then thinking about what do we do with it as a tool. And then lastly, there are other cities that have passed this ordinance. I think Somerville passed it in 2018 or 2019. Other cities, why has it been taking us a bit of a longer time? Like, what are we learning? What have we learned from them? What are we trying to guard for in the intentionality with which we've been moving with this ordinance?
Well, I mean, I've been at it, back when I was still a practicing lawyer. We worked on this in a lot of cities and towns. It's been a key prerogative of the administration to pass a wage theft ordinance as part of the mayor's platform. I can't speak to what happened before we got here. I know it's been a very important thing. We had some other stuff that, went in front of it, but it's been a very important goal to pass a wage theft ordinance, since we came in. but, you know, having the structures in place to do it, setting up the cabinet, getting the cabinet up and running and staffed and having it led, and because they're obviously going to be the ones that are going to drive this. So there's been some predicate steps that have slowed us down, but, you know, now there's no time like now.
And do we know how it's been working in other jurisdictions?
I know that the one in Chelsea has been I have heard directly from labor organizations that it's been a tool that they've relied on. I believe the same is true in Lynn. I know I've heard that one. I believe that there is Northampton, out in the western part of the state, I've heard of labor organizations and workers rely on that. But I'm not aware of a sort of central repository dealing with how effective they've been in general.
Okay, thank you.
I would also add too, is that Boston is so complex as a city within the state. I don't think there's much comparability there. I would argue that the City of Seattle's Office of Diversity and Inclusion, or Racial Equity Office, has some comparable mechanisms that we've studied that was very successful. Obviously, San Francisco, our city, city-to-city learning partner has good comparisons. But I think, again, it really bounces off to the state law that helps you intertwine with the compliance structure in your AG's office. So we're still learning on how to navigate that, but I would hesitate to compare Boston's effort to Chelsea or Somerville, for example, especially if, you know, some workers are transient across those neighborhood lines.
Thank you. Thank you, Chief. Thank you, Chair.
Thank you. Councilor Flynn?
Thank you, Madam Chair. Again, thank you to the panelists for being here. Jody, I had an opportunity to attend one of your workshops a while back in Chinatown, in Trent as well. Know Your Rights. And you included the Chinese Progressive Association. The discussion was very informative. It was in Cantonese as well. It was translated, interpreted, and it went over very well. And just wanted to acknowledge your team's work on that issue. And so my question is, if someone is being exploited, say at a restaurant worker, do they feel more comfortable talking to someone in their community, like the Chinese Progressive Association, Community Labor United, or do they feel more comfortable going to a government official?
Yeah, I think they feel more comfortable going to a community institution, which is why we've worked so closely with the worker centers, and those partnerships have been really critical to our Know Your Rights work. We know that they have language capacity, trust, expertise, history, so that's part of our work this year. It's been part of our enforcement, a part of our wage theft strategies this year, and will continue in the future, and the partnerships are really critical, and it's budgeted. We pay our partners to do the work with us.
Thank you, Jody. And Tran, I know you've been working on this issue literally for 6-7 years, and you've done a terrific job. And I just want to acknowledge that as well. We talked about the Boston Jobs policy, Boston Jobs for Boston Residents policy. And under Mayor Flynn, he established the Boston Employment Commission basically to enforce that policy. So my question would be, and I support this ordinance 1,000% that we're proposing, but when this is passed, and I think you've touched on it a little bit, but maybe if you can give us a little bit more information, what is the enforcement piece of it, and how do we know that workers, when they are exploited, that there will be some penalty, there will be some opportunity for justice, and that Boston will follow up to ensure that when we do have this ordinance in place, that there is some level of enforcement to it.
Thank you, Councilor Flynn, and I respectfully like to correct you. It's not 6 or 7 years, it's 10 years.
It's 10.
Yeah, it's way too long, my friend. I mean, one of the things and one of the charge of the cabinet is to streamline the compliance infrastructure of the city. So you have BRJP, you have living wage ordinance, you have prevailing wage. So you have a lot of different ordinances and executive orders and legacy programs over the course of the years. They're all well-intended and great, but we need to find a standardized, efficient way of making it simpler for businesses. Because again, we need the businesses. We want to do business in Boston. At the same time, we want to make sure that the businesses that we're doing work with adhere to value statements and laws. And so we're balancing that by creating an infrastructure and streamlining that, because at the end of the day, we won't be able to have 10 staff for this, 4 staff for this, or 6 staff, but we want to make sure that that overhaul meets the needs of businesses and workers at the same time. Now, we're starting a strategic planning process overall for the cabinet, but we do want to hone in on bringing someone on with organizational development and process improvement skills so that they can help streamline a lot of that. And, once you have that streamlined process and a plan, obviously the best thing to do is to get the buy-ins from departments that matter. So for example, procurement, auditing, the law department, the planning agency that does the Article 80 process, because we know construction happens there, ZBA, and getting those influence leaders to buy in and then train staff from frontline all the way up to the supply chain of each agency, so there's real buy-in, from the entire agency in the city of Boston. And I would reiterate what Lou has stated, is that Mayor Wu is dedicated and believes in this work. I am so happy that this has, resurfaced back, because that energy needs to be refocused to do better.
Thank you. My final question would be, we have seen over the last 4 or 5 years, we have seen workers that were injured on the job, hurt on the job, in some cases, unfortunately, died on the job. Many times, the fault is with the company for not addressing safety issues. My question is, in my opinion, that company should not receive a city contract until all safety issues are resolved and that worker's family is treated fairly. So I want to compare that situation to this proposed ordinance, again, which I support. But are we holding these construction companies accountable for any type of injury that a worker faces on the job, and what type of penalty have we already imposed on companies, so we can use this as an example for enforcement when we're doing this ordinance as well?
Yeah, I can answer that. It comes more in play at the time of permitting. When someone is seeking a building permit with the City of Boston, and that's either a building permit with ISD or a permit with the Public Works Department, because as we know, trenching and road work can be very dangerous, they need to disclose any previous OSHA violations through the Maddox-Higgins affidavit. That's one piece of it. But thanks to the support of the City Council and leadership, we did pass a new ordinance, and that went into effective December 2023, that in addition, we take it one step further. Anybody who's seeking a permit must also sign an affidavit that they have done a hazard assessment and that they have a plan in place to protect their workers and that they are going to train workers in a language they understand on that plan. And that for projects larger than 50,000 square feet, there's someone on site at all times, a site safety coordinator. Again, this is at the time of permit, this is an affidavit, but we have really worked hard to ensure that education and outreach is part of it. Last year, we did training, free OSHA 30 training and free OSHA 10 training, English and Spanish. We're doing it again this year because those contractors, and it was sold out, contractors are looking for that health and safety training. That doesn't get at the contracting, and there's currently no disclosure process around OSHA violations at the time of contracting. It's focused on wage theft, but it does, when it comes time for permitting, become very important, and that's either with Public Works or the Inspectional Services Department building permits.
Thank you, Jody. Madam Chair, am I out of time?
I've been very lax with time, so if you have another question, please feel free to
No,
add it.
I want to be respectful to my colleagues. Thank you, Madam Chair.
I had said 6 minutes, but everybody has such great questions, I've been letting everybody go. Councilor Murphy?
Thank you, Chair. Thank you for all of that and answering the great questions that have already been asked. I see this as, three parts. We have union jobs that are working on projects in the city of Boston. We have small businesses, companies doing business in Boston. And we also have city contracts and licenses, right? And Monique Mitchell, she's already done the work, right? She tracked and cross-referenced, and 30% of the wage theft violations are attached to people that we give contracts to. So why do we even allow them to start the bid process is my question. Why would we even give them or allow them to submit the application? Because we know when it's lowest bidder gets the job, many times people wonder, how did they lowball that bid so much? It's because they're probably planning on making cuts somewhere, and if the cuts are related, I would assume 30% of them are expecting to make a profit because they're not going to follow these. So why aren't we already just stopping it at that point and then waiting for a letter, and even the way it's worded from the last executive order? And I do appreciate the conversations we already had about, do we publicly shame, like Lou was saying, but then you were saying, Jody, but then we don't want the company to completely shut down. Is the database accurate? Or Councilor Pepin saying, do the employees also, but does the employer have an opportunity to at least rebut? Are we sure that the letter that goes out is accurate, or do they have a chance, once maybe we check all the boxes? So lots of questions, but why do we even allow them to fill out? There's plenty of people who want work. It's not like we don't have enough people applying for these bids.
And just to clarify, the 30% is actually licenses. So 30% have license and 4% had contracts with the city of Boston. So it's a smaller number with contracts, thankfully, but it is a
Or
good...
larger than 25. A lot of bids could be multiple small bids. So
Total,
that
yes, that
percentage
is
is
100,
right.
and
A
this
lot
is
of the street
Yep.
shoveling contracts and others are small bid, 5, 10, but if you have a whole bunch of those small ones, it adds up.
Yeah, no, 100%, and we ask for disclosure at the time of bidding, and I think at that point, it's up to procurement law to define how we move through it. Lou, do you have anything?
No, aside from, much of the work we're going to do here, I think is going to fix the problem you're highlighting, and that, again, is something that I think should occupy a lot of real estate in the working session, because procurement and licensing are ground zero for making sure this ordinance works, so.
Because right now, if your license, is it always a year license? You could be 12 months out, you could be a while before, and it doesn't even say that they will absolutely deny it. It's may consider. So how can we legally tighten up even that language? And I know that was some of the stuff that Council Weber put in. How do we make sure that when we write a new ordinance that is addressing what I would assume was exactly what Mayor Walsh wanted to address, that it actually gives us the tools, or do we have the political will to just say, sorry, you're the low bidder, but, or even, I would say stop it before they even submit it, because then you have more legal battles to say, well, they were allowed to submit their contract.
Yeah, here again, I mean, I think that's a question we need to answer. Because I think at the end of the day, you're right. I mean, you know, that's the kind of thing that we should be going after. But at the same time, too, if we pass a wage theft ordinance that gets the city sued and the ordinance gets enjoined because we try to do something we can't legally do,
Right, yeah.
that's no good either, so.
Right, that's what I'm saying, this might be the best we can do, and if it's true that the current ordinance is the best we can do, what other tools do we have to put more pressure on it, right? So I think hopefully we have those answers before it passes. And also there's that dilemma, right, the small businesses, because if you shut them down, it's a bigger, it could be, right? But then if we're ignoring the employers, I think they're more important in this case. One question, I'm sure maybe you could help with this one, but many times, and you said it, they're not going to come into City Hall. They're probably not going to call the City Council's office. Maybe they'll go to like the Brazilian workforce, or they'll talk to, you know, at a community meeting. But if an employer does not want to file a complaint, but somebody, me, anyone knows, you know, someone's daughter, mother knows that it's happening, what rights does someone on their behalf have to file it? That's Jody.
There we go. Yes, anybody can file on behalf of other workers. There's an online form at the Attorney General's office, and you can say what your role is, friend, family, coworker. It is also can be completely anonymous. So workers themselves can say that they're anonymous and be really clear that they want to make sure that their employer knows that it's not them that's filed this complaint. So there's lots of protections for workers because retaliation is, though illegal, very common, to ensure that they have those protections.
Thank you. Thank you, Jim.
Thank you, Councilor Murphy. Before we wrap up, I just want to bring somebody down who's been very patient and taking time out of their day to come and provide public testimony before we go ahead and move to the second panel. So if you want to come down to one of these podiums, state your name, neighborhood and affiliation, and my understanding is that Council Mejia will be providing.
I'm going to put my colleague, Councilor Pepeng, to work. He's going to be providing translation.
Okay.
Dale.
You have the floor.
Saludos a todos, mi nombre es Manuel Ramírez.
Hello, everyone. My name is Manuel Ramirez.
Yo vengo a exponer el caso de lo que me estuvo pasando con un empleador abusador.
I'm here to speak about my case with my employer who I was experiencing abuse.
Mi experiencia fue muy desagradable ya que durante 4 meses estuve trabajando para esa persona, la cual era de las 6:30 de la mañana hasta 11 de la noche.
I'm here to talk about the experience that I had in that work environment for 4 months, where I would start my day at 6:30 in the morning and end at 11 p.m. at night.
Y desempeñando un sinnúmero de trabajo y quehaceres que no correspondían a lo que él me hubiera dicho que yo tenía que hacer.
And doing a lot of work and tasks that was not part of the job requirement when I was given the job.
Ya luego, después de ese tiempo que estuve laborando para él, me sentía muy mal, decidí no ir. Y ahí entonces comienza la forma de humillación, los problemas, y comienza como a botarme del lugar donde él mismo alquilaba para tener la persona para la calle.
And after the 4 months of experiencing this kind of work abuse, I began to experience retaliation from the employer, to the point where even the unit that I was renting, that he had some ownership of it, I experienced in losing that unit as well.
Y yo creo que esto no lo merece ningún humano, ya que es una explotación a un grado que un problema hasta mental. Yo me sentí como una basura.
And this type of exploitation that I experienced really affected me, and I felt like trash.
Y es muy difícil, pero es bueno que ya este tipo de personas paren, porque yo fui el único que tuvo el valor para desenmascararlo, pero muchos no pudieron, muchos se quedan callados porque temen que le pase algo malo.
You know, it took a lot for me to speak up, but in reality, I was the only one that decided to speak up. But there were so many more of us that were experiencing the same type of work abuse at that job.
Yo espero que esto sea algo que realmente valga la pena, ya que yo no lo hago quizás por mí, también por otras personas que desconocen de que esto se esté dando con personas explotadoras que te traen, pero luego es una realidad muy distinta.
I hope that we are able to go somewhere with this, because at this point, I'm not even doing it for myself. I'm doing it for a lot of the people that are experiencing this exploitation at their workplace, because it's something that no human should be experiencing.
Para concluir, yo creo que no hay palabra que describa lo que yo sentí en ese lugar, ya que como soy hombre, decía a mi mente, yo tengo que aguantar porque yo soy un hombre y tengo que trabajar para mandar, o sea, para estar allí.
There are no words to describe the type of environment that I was experiencing, but I will tell myself that as a man, I have to put up with it in order to bring money to the table and be able to provide for myself, and that's what I would continue to tell myself.
Es cuanto.
That's it.
Thank you. Thank you so much for your courage and your bravery coming forward. We'll collectively work together to, as Lou introduces term to me, vindicate your rights and loop in all the relevant stakeholders. I'll pass it over to Council Mejia, who has a question.
Y Manuel, no te vayas todavía, que tengo una pregunta. Cuando tú te contactaste con mi oficina, dijiste que te pagaban de $300 a $500 a la semana, ¿cierto?
Sí, correcto.
Yeah, so just so that you understand the impact. So he had reached out to my office, and what I was found to be alarming is that the rate of pay for the amount of hours that he was working, he was getting paid $300 to $500 a week for working over 80-something hours. And so that was pretty alarming to me. And also the other piece of dígame.
Sin embargo, no puedo durar mucho sentado, ya que en la parte de las plantas de los pies, por estar parado desde esa hora hasta la hora de cierre, creé como una costra muy, muy fuerte.
And now, to bring it even further, at this point, even my body has been affected, where I can't sit for a certain amount of time because I was standing for so long that I have to move my body in a way that is able to keep up with the way I was working.
Gracias por decirme eso. Y también usted dijo que él lo trajo aquí.
Sí.
So the other piece of the story is that the individual brought him here
Yeah.
from a different country to work under very interesting conditions. And so I want to just note that for the record in terms of these conversations, right? That this is what it looks like when people are taking advantage. To Lou's point, when he was talking about statutes and what has happened there, that's labor trafficking. Like, there is some real serious consequences that we need to really start looking into. Is because when people come forward, and it's not an easy thing to do, to tell your story, to do so publicly in a space like this, it takes courage. And so I just want to acknowledge, Emmanuel, que le acabo de decir que no es fácil a llegar a este país, a decir tu historia y tener ¿cómo se dice courage?
La valentía.
La valentía de poder contar tu historia aquí públicamente, sabiendo las consecuencias que también te puede perjudicar. Pero si las personas como tú no hablan y no dicen lo que están pasando, después nunca las cosas van a cambiar. So, te doy las gracias por venir aquí y dejar tu historia con nosotros.
Gracias a usted que me abrió la puerta y gracias porque usted está desempeñando este papel para que más personas sepan la realidad de estos abusadores, explotadores de personas que solamente se valen de sus conocimientos para exprimir a las demás personas que no lo tienen.
Thank you to you for bringing me here and for opening up the opportunity to have this conversation, because this is something that a lot of folks are experiencing and we need to bring light to this exploitation.
Thank you. Gracias, Manuel. And thank you for allowing me to take the mic, Chair. I just felt it was important because there were some parts to his story that I thought would be relevant to what we're talking about. Gracias, Manuel. Tú te puedes sentar, te puedes quedar a lo que tú quieras. Es tu día hoy, pero si te quieres sentar, siéntate, y si ya terminaste, también.
Muchísimas gracias a todos los presentes. Gracias por escuchar mi testimonio y tomen en consideración que quizá esto fue por mí, quizá esto me pasó a mí, pero hubieron muchas personas que no tuvieron la valentía ni la gallardía de venir a exponer este caso por temor a que le pueda pasar algo peor.
Thank you for allowing me the opportunity to be here today. This not only happens to me, this happens to so many of us that are experiencing this on a daily basis, and that they're scared of retaliation from their employers. So thank you so much for having this conversation.
Thank you. Gracias.
Muchísimas gracias.
And to my council colleague, you didn't take the mic, you're passing the mic to people who are actually living through some of the things that we're talking through, and that's something you always do, and I respect that, so I appreciate you. I don't have any, well, I do have one comment just about the database and Do It, just underscoring the importance of Do It to my colleagues come the budget. I always push that forward and advocate for them. It sounds like they have a lot of work to do. I guess my one question is if that work is coming out of the capital budget or they're doing it out of their operational budget, if that's a question I have to follow up on. If it's building a software program, typically it's through the capital, but.
You know, I'm not sure. I asked for help and they came to help us, but I can find out how that's what it is that's paying for their time.
Great, thank you. And a lot of my questions are going to come or should be focused in on the working session about how to grant authority to the Zoning Board of Appeals, to the Licensing Board, and all of that. So I look forward to that subsequent conversation. I'll pass it to my colleague for a concluding remark, is what he had framed it as.
Yeah, well, thank you, and thank you to the panelists. And, you know, one of the main drivers of why we're having this hearing is because the work that the Office of Labor Compliance has already done in looking back, you know, years back to 2019 and finding that so many of our, you know, because the executive order was there, but it wasn't really being enforced, we were awarding contracts to people with wage theft violations. And so I just, you know, look forward to working with you, and thanks for the work you've done up till now.
Thank you, everybody.
Thank you.
Appreciate your time. Next up, we'll have a panel on behalf of local unions and community. We have Terry Gerstein on Zoom, who's the founder and director of the NYU Wagner Labor Initiative. We also have Darlene Lombos, Greater Boston Labor Council. If you folks would like to come up and take a seat, you're more than welcome to. We have Noel Xavier from the North Atlantic States Regional Council of Carpenters. Charlestown's very own Frank Murray, Local 7 Union Workers, who's the president. Thank you for being here. And Chatton Green on Zoom, who is from the Greater Boston Building Trades Union. As folks are getting situated here in the chamber, I'll pass it to Terry, if you are willing and able to start with your testimony.
Yes, thank you for the opportunity to speak today. And I just want to check and make sure I'm trying to share my screen. Is that working properly?
It is working. We can see you, hear you, and also see the presentation. Thank you.
Excellent, thank you. So I'll start out just briefly introducing myself. My name is Terry Gerstein. I direct the NYU Wagner Labor Initiative, which, among other things, helps state and local governments get more effective in protecting and enforcing workers' rights. Previously, I ran a similar program at the Harvard Center for Labor and a Just Economy, and before that I worked for 17 years enforcing labor standards laws in New York, including as the Labor Bureau Chief in the State Attorney General's office. So I'm going to give a little bit of context and just share some thoughts on the ordinance. And I also just want to make it clear, I'm not here as an advocate, I'm here as someone more of an expert capacity. So I just want to give some of the national context in terms of why is there so much wage theft. We've heard from the Boston team about some of the statistics in Massachusetts. But I wanted to zoom out and give a little bit more context about why this is so frequent. One is that there are really inadequate enforcement resources. Massachusetts has one of the more robust state enforcement entities in the Fair Labor Division and the AG's office. Many states don't have any or very few labor investigators. And at the federal level, the U.S. Department of Labor's Wage and Hour Division only has 664 investigators for the whole country, which is the lowest level they've ever had. Lou Mandarini talked about the union density in Boston and in Massachusetts, that I think he said it was around 14%. I don't know if he was talking about public and private. Generally, public sector density is higher than in the private sector. That very low union density rate also enables more labor violations. Not only does it make it hard for workers to report violations, as he described, but it also, because there's fewer places for workers to go, but unions basically, when they're in a workplace, act as on-site monitors, and they make it easier for workers to report violations without being afraid of retaliation. Then there's also the growth of forced arbitration and class waivers, which some of you may have heard of, which often prevent workers from being able to bring their cases in court, and they also prevent workers from being able to bring a class action. And what this does in practice is that it effectively extinguishes their claims. There's research showing that about 98% of the claims that would have been brought if workers could have gone to court are not brought when workers are subject to mandatory forced arbitration as a condition of their employment. So that puts more pressure on government actors and public enforcement to do something about this problem. And then there's the problem of the fissuring of the workplace, which Brandeis professor David Weil he coined that term, and that is increasingly companies using subcontracting, outsourcing, temp and staffing agencies, and that also leads to a higher rate of violations for various reasons, including that each layer needs to make, the intermediary, the middleman needs to make some money. And so these are all factors that lead to really widespread impunity. And I want to share a formula that is really common sense, but economists came up with it and wrote about it. And it's basically that employers won't comply with the law if the expected penalties are small, either because it's easy to escape detection or because the assessed penalties are too small. So in other words, the likelihood of compliance for unethical employers, plenty of employers do comply because they want to be compliant, but of the unethical employers, the likelihood of compliance is kind of a function of the likelihood of getting caught and the consequences of getting caught. And so I think that as we talk about licensing and permitting, that is one way of significantly increasing the cost or consequences of getting caught. Similarly with procurement. There's a lot of ways that local governments around the country are getting involved in advancing and protecting workers' rights. Some of them you've already done here in Boston, like creating a dedicated local labor office. But one of them that I really want to focus on during this conversation is the one that is number 7 on this list, which is infusing labor considerations into contracting and into license holding and the permitting process. And a colleague from Local Progress, which is a network of local progressive elected officials, she and I wrote a report about what local governments are doing on workers' rights in general. And then this year, recently, we wrote another report specifically for localities in states that have state preemption of local lawmaking. And so while Boston doesn't have the same kind of local preemption that cities do in Florida or Texas, there are some limitations that make the recommendations in this report relevant for Boston as well, I think. So in terms of the current proposal and the current ordinance proposal, there are a lot of strong components of it. The basic goals, obviously, ensuring that public funding doesn't go to bad actors who have a history of repeat or egregious or unresolved violations, incorporating labor considerations into the licensing and permitting process, both in the initial application phase and in an ongoing manner, using local government to help workers navigate other resources, as we heard the Boston team talking about that it's easier for workers often to go to local government, and then creating public disclosure resources like the database of violators. As I reviewed the proposal, which is quite long, and I don't know every detail of the fine-tooth comb, but some of the initial top-level questions and thoughts I had. One was about capacity and whether the Office of Labor Compliance and Worker Protection would have the capacity, for example, to review all applications for licenses. That seemed like an enormous amount of work, and it seems more valuable to incorporate labor compliance checks into the existing processes of the licensing and permitting entities. And then there's a question also of right-sizing consequences. We've heard in the prior testimony about how some violations are inadvertent and or maybe de minimis, while others are really intentional. And so it's important, as you think about the procurement, licensing, and permitting consequences and requirements, to have some kind of distinction and clear guidance for the city officials who are going to be implementing this about, what are the right consequences for what level of violation. I think this issue of implementation by the licensing and permitting agencies is so important. As I read the draft ordinance, it seemed only to require informing the agencies about violations, but didn't really require them to take specific action. And so I think that really it needs to be very, very clear under the ordinance, under the statute, and in terms of implementation, that the licensing and permitting agencies have certain required actions they have to take. And then procurement, again, it's the same thing. To the extent you can get the procurement officers throughout the city, and I know that procurement is decentralized, which can make this difficult, but to themselves incorporate labor considerations into their own processes without, needing constant involvement by the city labor office. That is something that would be helpful. The city of San Diego, I think, is really a great model for doing this work, and I would recommend that you invite the director, Brandon Butler, to speak with you and to testify at some point. Some of the things that they're doing, the city office was created to develop protocols for denial, suspension, or revocation of licenses, permits, or county contracts, and so they've really been working on that. They created a wage theft judgment dashboard with all the wage theft judgments in the county. And both Santa Clara and San Diego County have implemented programs, they're 1 or 2 years old, in which when restaurants have outstanding unpaid wage theft orders under the state's labor commissioner's orders, the counties are basically sending letters to all the restaurants in the county that have not paid the money that is owed to workers. And they send a letter saying, if you don't pay what you owe, your license will ultimately be suspended. In Santa Clara County, it's 5 days. In San Diego County, it's indefinitely. And basically, you can see here, it's an infographic of what San Diego County is doing. They send one letter, they send an angrier letter, and then a more stern letter. And then at the end, there's an opportunity for employers to have a hearing. And currently, they have, I think, 3 hearings that are scheduled to withdraw restaurants' permits to operate because of unresolved, outstanding final orders of wage theft. And this is just some data from the program. I'll note a couple of things. One is that there were conversations on the prior panel about final orders, and I think that is very important from a due process perspective. And here, these were all final orders by the State Labor Commissioner's office. One unfortunate thing about aspect of this program is that because of the delay in investigating and getting a final order in a case, the permitting result is there's a time lag between the wage theft and the permitting consequence. The legal authority In some cases, in Santa Clara County, for example, and in other places, there's just a catch-all provision that says the entity has to, the permitted entity has to follow all local ordinances or state laws or regulations. And so they've used that as being sufficient as a basis for doing this. San Diego also has trained their procurement officers in using their wage theft dashboard. They created a program for cross-checking wage theft compliance with building permitting. So when a contractor asks for a building permit, they check to see about the wage theft compliance. And then in certain contracts with the county, they're holding back 5% in a wage theft retention fund so that if there's wage theft on the project, there's money to pay. The New York City Comptroller's Office recently created an employer violations dashboard and employer wall of shame. It includes local violations of the local paid sick leave and other laws, but also state law, also certain federal laws, the Fair Labor Standards Act, OSHA, the National Labor Relations Act. And there's a lot of different kinds of benefits to this dashboard, including, ideally it will enable procurement officers to readily check and see when there's a contract going out, what is the history of a given employer. Also, one other benefit of this kind of comprehensive dashboard as well, we heard so poignantly about what it's like to be a worker facing wage theft. And worker organizations have said that this kind of dashboard is very emotionally impactful for workers because they can see that they're not the only one, and they can see if their employer has a history of violations. And there's also, as I noted, an employer wall of shame highlighting some of the very worst actors. The New York City Comptroller's Office also has a public database of all city contracts. So if I imagine Boston has something similar, but if not, that's useful for cross-checking the violations and the city contracts. A few other examples: in Austin, Texas, there's a wage theft officer who checks violations of potential city contractors. In Florida, there are some counties that have created they're preempted by the state, but they've created mediation type programs to address wage theft. So even though they can't strictly enforce it, they bring people together and try and mediate it. There are a number of cities that have grant programs that award funds to worker centers and advocacy groups. And in some of those cases, the question was asked about, if Boston can't directly enforce wage theft, what can it do if it's not a contractor or permit or license? In some of these cases, like in Iowa, the state isn't very active, the state labor department isn't very active, there's no local entity, and so there are several localities that simply give grants to worker organizations who themselves can bring cases. The DCAG's office also gives grants to worker organizations that themselves file lawsuits. And then the Denver Mayor's office also plays the navigator role that we've heard about. A couple of additional thoughts, I'm almost finished, regarding contracting, licensing, and permitting. One is that there are options beyond the binary of either denying or revoking a contract or a license or a permit or doing nothing, right? It doesn't have to be all or nothing. You can require a wage bond like this proposed ordinance innovatively does. You can suspend the license or permit for a finite period. On a contract, you can require third-party independent monitoring to ensure compliance. You can do San Diego's 5% retention. You can require certain actions by the employer, like make them go through training. And then I would also recommend that people review Jobs to Move America is an advocacy group that created a U.S. jobs plan that requires bidders on contracts to give information about all the jobs they're going to create and all of the wages they're going to pay, and then incorporates those terms into the contract as a material term of the contract. And then my final thoughts are, as you think about wage theft, one goal is redress for workers, and another goal is prevention. I tend to focus a lot on prevention because I'd rather not have this happen in the first place than have it happen and have good ways of addressing it. But I think as you think about all of this, it's really valuable to think about the economic formula of, compliance of unethical employers depends on, the likelihood of detection and how bad the consequences are going to be. And losing a permit, having a license suspended, even for 5 days, causes reputational harm, financial harm, and otherwise that really can change the consequences and change the calculus for employers. But you do need to have very clear authority and direction for government actors whose main job is not labor related. In the licensing agencies, they may feel like, this is not my job. Like, why are you adding this into what I already do? And I think helping them understand and giving them very clear legal authority and very clear directive that this is now part of their job is very important. That's all I have, and I'm happy to take any questions. Thank you.
Terry, I just want to thank you for providing such a robust and comprehensive presentation. Again, for my colleagues and everybody else, this is within the folder. I'm sure we can stand to benefit from your national expertise and what you've provided here for us. So just thank you so much for coming and providing that presentation. We will transition to a local expertise with some of our local labor leaders here. I will defer to you all who wants to go first, but again, we have Darlene Lombos, Frank Murray, and then, oh my goodness, I'm so sorry. I think this is, remind me of your name, sir. I apologize.
Noel Alexander.
Noel, okay. Darlene?
Okay, dudes are telling me to go first, so I shall. Thanks to Boston City Council for this hearing today. This is so strange because like I have this whole speech written and I'm like, I've been listening to this thing, I'm being like, Trin and I have been doing this for 10 years, more than that. And before that, wage theft was happening. So even decades before. So I just feel like I just want to make that clear. And if you ever want to know the stories of what we did in the very beginning to get a coalition of worker centers and unions together to come up with this very legislation. This is an example of bottom-up legislation where people came in a room who were most affected by the issues and crafted ideas. And then we worked with Lou and lawyers to say, what is it that we can get in policy? So back in 2014, we were doing statewide legislation and trying to bring attention to wage theft, but also doing municipal ordinances. There are about almost 20 across the state that have been passed. Some are stronger than others. Boston was the first one that did an executive order because we wanted an example very fast. That was a movement building opportunity for us to have a mayor that was willing to do that. Now we have a mayor that's willing and a city council that's willing to push this even farther and to codify all the things that we've done. So I just wanted to give a little bit of history because some people don't know that this legislation is the work of people who are most affected by the issues being brought together by a coalition, Community Labor United, with unions and community groups and worker centers to then craft from their own ideas and solutions what it would take to deal with wage theft. So I love the examples that have been given in other cities and other states. I'm telling you, this, what you're doing today, is a very good example of bottom-up legislation. So I just want to make sure you understand that. I also just want to, thank you for working so closely with this administration on making this such a strong piece of legislation, because that's what it takes. It actually takes the back and forth of people who are experts, who have been working on this for a while, and also people who are new, who don't even know about the issue, in crafting, again, understanding the history and making this happen. And we like to say, teamwork makes the dream work. So we are really, I know it's like so long in coming, but I'm glad we're codifying accountability. I also just wanted to make sure you understood that our first action was in 2014, and it was right here in Boston. The Greater Boston Labor Council took leadership in doing an action on AMC Lowe's here in downtown Boston. They were contracting to a cleaning company, and 6 workers were not getting paid. And they found themselves, they were living in Chelsea, and they found themselves over at one of our worker centers, strongest worker centers, Chelsea Collaborative, now known as La Colaborativa. They helped them filed a case with the Attorney General. Attorney General did an investigation, said they owed $29,000 in back wages, said they had, fees for not following through with following the law. This cleaning company, right? That was subcontracted by AMC Lowe's. Over a year later, they still had not been paid. So we did an action. 150 people walked into the lobby of AMC Lowe's and said, you should pay these workers, AMC Lowe's. Your cleaning company is not paying the workers. Within 48 hours, there's a check for $29,000 over at La Colaborativa, right? So this is also about power and political will. And so you can say things like, I know, what's it say? I don't know, I wrote it down, adjudication, and I don't know, what constitutes these things. At the end of the day, people aren't getting paid. They're not getting paid an honest day's work for an honest day's pay for an honest day's work. And that is the bottom line. We need our workers in this city to be paid for the work that they're doing, and we need them to be able to contribute to the families and the communities to make our community strong. So that's the connection. That's just what this is all about. So I don't know. I had some other things, but I had some stats and facts and all that. But you know what? You don't need to know that. All you need to know is that we, as unions and worker centers, walked into AMC Lowe's and got the company to pay back wages because there was worker power in that room, and they saw that. We need government to basically help us out, because we're going to still be out in the streets and still walk into AMC Lowe's or wherever work site is being violated or a violation is occurring. But we need government to work with our employers, to work with us, to get them to follow the law. Basic.
Try following that.
Good afternoon. Thank you to the chairs and the city council for allowing me to speak today on this issue of wage theft in the construction industry, which is what I'm going to speak more about through my lens and what I do. My name is Noel Xavier. I'm the Director of Organizing for the North Atlantic States Regional Council of Carpenters. Our union and our organizers work every day to shed light on the actions of unscrupulous contractors, to ensure that every worker is aware of their rights and to help workers get paid, just like Darlene was talking about. We also understand, as part of the discussion, we're going to be trying to work on putting some stronger maybe language into the ordinance here in Boston. We've been part of different ordinance conversations and discussions and helping pass different ordinance languages across the Commonwealth as well. We have some thoughts on some places where the ordinance can be improved. As a working session, getting into the details of the legalese, we have attorneys that work with us. That'll be helpful, but just in a larger kind of context, I think there's some room for encouraging apprenticeship programs for a certain type of construction work in the city, creating up-the-chain liability as well, and also room for improvement on just the application of other types of tax relief, and not just TIFs. There's a lot of different ways that contractors and developers receive monies for their projects, and I think there's some opportunity to include all of that, because at the end of the day, it comes down to the stick that the city can hold over developers and contractors to really kind of showcase that there is some consequence, because what unfortunately I see out in the construction industry is contractors and developers that have take advantage of a system, a legal system, of being able to propagate this exploitation without having liability fall on them. And all the liability falls down the chain to the subcontractor, second-tier subcontractor, third-tier subcontractor, where it's essentially 20 workers that work for somebody that knows them and has a company by name only, but doesn't really have anything else. I'd like to share with you an example of wage theft that's happening right now here in Boston. Just 2 weeks ago, our organizers doing job site visits, because my department, I deal 95% of the time with the non-union, not the union side of things. And we're on job sites talking to workers every single day, asking them how they're doing, and how they're being treated, how they're getting paid. And we came across a project here in Boston where one of the workers, after talking to one of our organizers, called him in the evening and said, "Hey, I haven't been paid in a few weeks, and it's not just me, it's 18 other workers here on the project." We asked them to come in to kind of give us all the details of what was going on. 6 of them came in. The other workers felt intimidated from coming in and talking to us. I'll read you the template of what they're going through. The only thing that really changes from worker to worker is how many hours and wages actually that are owed to them. But this is, here goes. I started working on this project doing the wood framing in May of 2024. I was told I would get paid every 2 weeks and that there was a 2-week withholding period before receiving my first payment. This is a common practice when working in wood framing. I received my first payment at the end of my 4th week of work. I was paid in cash. We were all told that we needed to work 10 hours daily, and we also worked 8 hours on Saturday. No overtime was paid for any of the hours above 40 hours. The person who paid me was named Ramon. I was working with 18 other carpenters, and we were all paid the same way. Felipe Estrada was the foreman on this project. He worked for Evolution and directed us on the work that needed to be done daily. Payment issues began in the 6th week of work. Ramon said that Evolution was not paying him. When we complained to Felipe about not being paid, he put us in contact with the owner of Evolution, who told us to keep working, please, that he would make sure that everybody gets paid, but that never happened. I am owed X for the amount of hours X. This is, unfortunately, just a typical situation that we encounter every day, because workers like this that come forward only come forward when they feel there's no other recourse and when it's large enough that they feel this is really, really bad. Every worker we talk to knows someone or themselves in the last year, 2 years, 5 years has gone through some sort of wage theft. And when they express wage theft, they mean, I haven't gotten paid. I didn't get paid for 2 days, the last 2 days that I worked with this guy. I didn't get paid for the last week that I worked with this guy. I just don't work with them anymore because I go and work with somebody else. But the reality is the non-payment of overtime is incredibly rampant because everybody's working. The wages are low, and to make up for that, you work more hours. And workers are working 48, 50, 60 hours a week, where there's never any payment for overtime. So for us, I think here in the city, if any tools that we can utilize through an ordinance to make it where contractors understand that there may be penalties that might affect me financially at the end of the day, that's the only way that one of the only ways that I see, because a general contractor, he has a lot of sway on what happens on this job site, even though they hide every day behind the laws that exist and say everybody down the chain has signed a contract and they said that they're going to follow the law. So if an enforcement agency comes and knocks at my door, I point them at them. But the general contractor has a lot of sway with who they hire to build the projects. And when all we hear all day long is that we need to go with the lowest budget, that is the problem, because the lowest budget is a budget reached by unlawful means. And when you're comparing everybody else, forget comparing it even to unions, comparing a low budget with a non-union contractor that does what he's supposed to do and pay the taxes and pay the insurances and pay all that, there's a price difference of upwards of 30% with a contractor that doesn't pay any of those by law mandated taxes and insurances. So anything that we can do, any help that we can provide in helping with the process, we're happy to help. Thank you.
Thank you. Frank, if you'd like to go, and then Mr. Green, I know you're on deck waiting. We haven't forgotten about you. You'll go after Mr. Murray. Go ahead.
All right. Thank you, Madam Chair. Thank you, Councilor Weber, Councilor Mejia, and Councilor Murphy and the past councils that were in here. And also thank you to everybody in past government that has put this on the forefront throughout the city, because it is the kind of stuff, like Sister Olombo said earlier, you can prepare these speeches and get all these stories, and it's what keeps you up at night when people don't get paid for work, especially when it's from someone that comes from on the building sites. I'm out on the job. If I have an issue, I guess I'll just make it towards me. If there's an issue on my project, I have a business agent or a representative to call and say, hey, this guy didn't give me such and such hours, 1 or 2 extra hours here or there, or we worked on Saturday and, it's got to be double time or things of that nature. And it's typically very simple, where it's a phone call from the business agent to the signatory contractor, like, Lou Mandarini mentioned earlier, who will live up to the contract. We're all represented workers, and that's easy on the union side. On the non-union side, I mean, you heard from our friend earlier who spoke. I don't know what workforce he came, what place he came from, but when you hear a story like that, it's something that it's first anger, then it's sadness. It's many emotions, none of them being good. When there's somebody that's cheating a worker to that extent, to the point where they're housing, it's almost like a monopoly in that sense, where you live where you work and you pay me the rent, and if you don't do this, I don't pay you, and it just seems un-American, and especially to our future American citizens that have to deal with that, it's just not right. I guess getting back to the union side on where, I'm from, which is a privilege to be, and you hope to give everybody that option to be able to work under a union umbrella and have the representation. The prevailing wage rates are usually set towards union wages, whatever trade you may be under. They tend to, reflect right there a couple bucks off of what our wages are as a union. And the misclassification, you hear that term a lot in this room. The contractor is an iron worker that's working on a prevailing wage job, call it a bridge maybe, or a school or something like that, where it's, state or city funded. Taxpayer money, they're going to misclassify their worker. If you're an iron worker, you're going to get paid X amount. We'll call it, $100 an hour. But if you're a carpenter or a laborer, it's going to be $20, $15 less. And throughout the day, they're going to misclassify that worker as a carpenter or a laborer. But they're going to be performing iron working duties, And that's where the cheating contractor is, to the points that were made before me, is making their hay, basically. They come in with that low bid, and they're chopping off the knees of the working force to make their budget, to make their profit, excuse me. And that's sad. That's sad to see, especially in the city of Boston or the state, nevertheless. Like, when you live in a city and you're, paying all the taxes to help fund that project, and there's an out-of-state contractor that's coming in, and that they're, cheating, and the city is trying to help, and I know the union is, but to have this law in this ordinance in place would be huge to put these people's feet to the fire, the bad actors. And I guess to the point where, like, if there was a lot of questions asked, and what could we do and how could we do it. I know in specific trades, I know in the ironworking business, we have compiled many of files against contractors, like under the DCAM certification process, because I know there's a lot of non-union folks that have that, and we don't have as many because it's hard to meet those regulations, and I know it's through the state, but we've compiled a lot of information. So I think as a tip to the city hall would be, work with the specific trades and their unions on those specific contractors, because I know on our side in the ironworking, at our union hall, we have a long list of contractors that, it's just we don't know where to go with that information, whether it's the State House or whether it's City Hall, or, and then next thing the project's over and, we're on to the next, and things get busy, and it does kind of get not left to the wayside, but then it's like, I seen their trucks again, they were just in Jamaica Plain, now they're in Charlestown, now it does, I would say as City Hall, as elected officials, use unions, what do you guys have for information? What can we do? What do you have, and compare notes? I was reading a few of the ordinance, the packet that I was emailed over, and just a couple of quotes, like from studies have repeatedly shown that wage theft is concentrated among low-wage workers, women, minorities, non-citizens, and non-union workers, Also another quote, requiring city contractors, subcontractors, and bidders to comply with applicable federal and state wage laws. Our books are wide open in that sense on the union side, where, everything is known, what we get paid. And it's that misclassification from the non-union side where you don't know where they're cheating. And also with Local 7 and the Boston Building Trades, we promote diversity. We promote Boston City workforce, all the things that was spoken about before, where we want our kids to work here, we want the community to work here, things of that nature. So just leveling the playing field, and, you know, I guess back to my earlier point, I'm sorry, as I'm rolling through my notes, is the certified payrolls, you know, going back to using the unions, leaning on them a little bit to get access to some of those certified payrolls, because I know that the unions do a lot of hard work on that, the organizers and things of that nature. So City Hall would, you know, please reach out, and we can try to put an end to some of these bad actors. And that's about it. I don't even know if I introduced myself, so I apologize. My name's Frank Murray. I'm from Local 7, the president of the Iron Workers. And Shaitan, I do see you wearing an Iron Workers shirt, and I want to say thank you for that, brother. I'll forfeit the time to you, my friend. Thank you.
You forgot to mention that you're a proud Charlestown resident too. So
yes,
that's also
02129 as well, yes.
Very
thank
important. Thank you so much. Shaitan, the floor is yours. You're muted.
Okay, can you hear me now?
We can hear you.
Perfect. Good afternoon, everyone. My name is Shaitan Green, and I'm honored to speak before you today as a Roxbury resident and a proud leader of the Boston Building Trade Unions. Today, I want to address an issue that goes. Today, I want to address an issue that goes to the heart of fairness, dignity, and respect for all workers, which is wage theft. First, I want to thank all of you for your dedication and hard work. It's because of you that our communities thrive. Your commitment deserves recognition, and most importantly, workers' rights deserves enhanced and advanced protection. Workers' rights, wage theft is a grave injustice that undermines the very foundation of our labor force. It occurs when employers fail to pay workers what they are rightfully owed, whether through unpaid overtime, denied benefits, or outright wage theft of wages. This not only robs workers of their earnings, but also strips them of their dignity and security. The impact of wage theft extends beyond the individual worker. It affects families who rely on every paycheck to make ends meet, to put food on the table, to pay rent, and provide for their children. It undermines our economy, as honest businesses that pay their wages are undercut by those who exploit their workers, and it erodes trust in our institutions, as workers feel abandoned by a system that fails to protect their rights. This is why a strong wage theft ordinance is crucial. Such an ordinance will provide clear and enforceable rules that holds employees accountable. It would ensure that workers receive the pay that they have earned and create a fair playing field for all businesses. By defining wage theft and outlining specific prohibited practices that employees share every day, such as unpaid overtime, misclassification of workers, and unlawful deductions, there must be effective enforcement mechanisms in place, which we know includes establishing dedicated offices or officials to handle wage theft claims, conducting regular inspections, and ensuring swift and fair resolutions of disputes. Employers who engage in wage theft must face significant penalties. This not only compensates affected workers, but also serves as a deterrent to prevent future violations. Workers who report wage theft must be protected from retaliation. They should feel safe in coming forward to assert their rights without fear of losing their jobs or facing other forms of retribution. It is essential to educate both workers and employees about their rights and responsibilities. Public awareness campaigns can help ensure that everyone understands the importance of fair wages and the consequences of wage theft. Before joining the union, I was a victim of wage theft. When I bargained for myself to ask for a dollar raise from a certain non-union employer, I received it, but later found out that that employee took a quarter from 4 workers, and my heart was broken. We must do everything we can to prevent this from ever happening to anyone ever again. Bad actors need to be held accountable. As soon as we catch wind of bad practices, it is then our job, alongside with government, to act immediately. And it must be just as important to us as the person affected by wage theft. Together, we can create a fair and just workplace where every worker is paid what they deserve, and every worker who decides to take the brave step of speaking up is protected. Thank you.
Thank you, Shaitan, and I want to thank this entire panel for not only just being here today, but your decade, years plus worth of work into bringing us to this point. So thank you so much for providing that history. I certainly needed it in that context. It's so important, and providing your perspective. I'm going to pass it to my colleagues for any questions or comments they may have. Those who are left with us, I appreciate everybody being here for their time, but I'll pass it over to Councilor Weber for any questions or comments he may have.
Sure, thank you. Yeah, just Frank, first of all, we're talking about misclassification and prevailing wage misclassification as being a big problem when contractors say, well, that person's a laborer, even if they're doing electrical work or iron work or carpentry or anything else, and they pay a lower wage. That would trigger the requirements of this, and certainly I think would be grounds for suspension of a contract. And
Great.
I fully support you on that. I guess I had a question for Terry Gerstein. She's there. And I do think the sort of the thing I want to get right on this is the database and how we're going to use that database to be effective in our enforcement. And I don't know if we lost her, which is possible. I wonder how we can do that effectively and make sure we have the right division of labor. I know our Office of Labor Compliance, they do a lot of great work. I don't know if they have the staff to be able to do this, but I guess for anyone on the panel, Darlene, do you have any thoughts on how, having been involved this long in this fight, who would manage that database, and how do you think we'd be able to get our people in the field, procurement officers, license grantees, like what we should be thinking about as we do that?
Okay. The database is really important, absolutely. And I think that data is an important tool to be able to enforce and know what the problem is. However, I don't think that's the number one issue on the table or the number one tool. And I think that there's some incredible tools that Trin has already implemented that is being codified right now, which is the M16 form. We did not have that. There was no disclosure requirement from anybody who was doing bids or putting in bids. Having that is really important, and being able to put that in the procurement process from the get-go is key. The wage bond and requiring anybody with past violations being able to be required. Actually, can I just tell you a story really quick? Because there was a worker from the Brazilian Worker Center actually sitting around the table with all of us. It was actually current Mayor Wu and Lou, who was working for Siegel Reutemann at the time, a bunch of us. There's a couple carpenters there, there's a bunch of us. And he was like, man, shouldn't there be something that says that they can pay us? Like, shouldn't there be proof that they can pay us? And I kid you not, we were like, Lou was like, I don't know, is there a wage bond? Can we make a wage bond? And people were like, we can make a bond, we can make that shit, we can make that stuff up, we can do it, we can put it in an ordinance. And to me, that is the key to this whole ordinance, is that we had a worker that say, here's a problem. We had people around the room saying, we need to solve this problem, and we came up with that wage bond. So I love the database, and I think it's really important, and I know you do too, Counselor, but there's other things in there that I love a lot, like the partnerships with the community, the worker centers and all that. That's what I love the most.
Yeah, sorry, so on the wage bond, I guess, so it's in the proposed ordinance, and that we can require, I think it's up to a year of, do you have any thoughts on is that the right amount? Is that not enough? Are contractors who've had wage theft violations in the past, are they going to be able to come up with that amount? Or do you think that?
They have to have bonds for lots of things. So they have to have insurances, bonds. These folks know more that their own signatories are required to have lots of things. There's no reason why they can't prove that they can pay their workers.
Okay, and I guess, well, my question for Noel and Frank, I mean, how hard is it to get work, get these contracts for you, for your workers, for union workers here, where you have, like where you have people who are bidding against you who might have, not paid their workers in the past, and make a point of not having union workers on site.
Sorry, do you mind?
No, go ahead.
All right, thank you. So I think it's gotten almost to the point where the contractor has to sharpen their pencil so much on their bids that it's gotten down to like schools particularly, like there'll be 1 or 2 steel erectors that will be able to do that. And they've kind of just honed in on that market. I'd say on the ironworking side, we do fairly well on erecting steel and like Boston City projects. It's when it gets down to like the miscellaneous metals, which is like the smaller part of the contract, where it's the stairs, it's the railings, it's things of that nature where we tend to lose because the fabricators of these, the iron in that package, that particular package, always goes to a non-union bidder, but those people are, again, misclassifying their workers. They might have the foreman being the iron worker, and then the guys installing it are considered the laborer, but it's technically iron workers' work. So it's misclassification of workers, and it's misclassification of job duties in that sense. And I know you mentioned that, Counselor, that kind of stuff is going to be in this ordinance, and that's a great thing. But again, it's just those, and it's the out-of-state stuff too. I feel like there's a lot of the workforce isn't from, they might have a Massachusetts address, like their office or whatever that may be, but their workforce is from out of state. And that, where are they residing is a big thing, you know what I mean? Like, I guess it's for me, like the Horace Mann, the old Edwards Middle School to the Horace Mann now, there was good ironworking contracts on that. There was some steel erectors in there. It was a rehab, so it wasn't much, ground up ironworking going on. But we did lose the miscellaneous metals package, the small stuff where they were changing the railings and the ramps and things of that nature, to a contractor that I know has an address up north in Massachusetts. So they followed the DCAM certifications process, but their workforce is like New Hampshire residents and things of that nature, and they're not Boston residents. So whether it be the clerk that's there on the job that is like overseeing those things, if he or she could, kind of hone in on like, hey, what's going on? Who's, is Ben Weber's, I see you got Ben Weber here to work. Where is he from? Does he meet the criteria of, being a Boston resident? Okay, he does. If it's someone that's not a Boston resident, then it's like, hey, you won the bid for this reason. The Boston City Ordinance wants you to have X amount of Boston residents. It's a school. Like I roll out of bed and I'm in that school. You know what I mean? It's right next to my house. I know the contractor that was there didn't have Boston residents on it. The steel erector did. There was some good parts of it, so I can't go all bad, all negative. But there are some cheating contractors that are able to find their way around the edges and get there somehow, some way. And I just think it's because, one, they're cheating and they're just not meeting up to the requirements. So that's where I feel the contractors are. Just the cheaters are really working hard on cheating.
Yeah, and
I just have to just be very clear that bad businesses are actually lying and cheating, gaming the system, and undermining responsible contractors. It is a cost to the city, state, and federal government, actually, when the misclassification of workers, of independent contractors, our taxpayer dollars are paying for that. It's a cost to us individually when a business does not pay unemployment insurance, and is not classifying their workers as an employee when in fact they are. So contractors and subcontracting is what I think Brother
thank
Frank
you.
over here was saying,
Yeah.
both a misclassification of the job, but also as a misclassification as an independent contractor and not an employee.
Yeah.
And so that is so key, and it undermines responsible businesses who won't even put in a bid
Yeah.
because they can't compete on a level playing field. Wage theft and misclassification of workers and not paying taxes is baked into their bid, y'all.
Yeah.
It's baked in.
It's
Yeah.
a business model.
It is. And thank
It's
you,
a
Darlene. Thank you.
business
for-
model.
Yeah.
Yep.
And one of the things, from our perspective, in prevailing wage work, public work, our contractors, yes, we find cheating and yes, we follow, but just in the private work is where we see this rampant. And residential, it is just incredible. The deltas that we see sometimes in just one scope of work, let's say the drywall package on a building is upwards sometimes of $3 million. And there is no way that legitimately a non-union contractor where he has to pay the same amount for materials is going to be able to do the work with the labor force and save that much money. It's an illegitimate number. And that's one of the things that we find, like Darlene says, this is baked into the numbers. And, because of the shortage of being able to have the enforcement agencies out there and just everybody's short-staffed and underfunded, it's very, very difficult. This project that the workers that came forward received mass housing money, $15 million in tax funds to help build this project. But herein lies the problem, right? The contractor comes in and says, this is the price that I can give you. Everybody's like, oh, well, we need to go with the most affordable way to build this. But what's baked in is the exploitation already, all the way down the chain. And guess what? None of the top tier people are really vulnerable to liability. It's anybody that creates that cheating down the ladder that gets pinned against the corner, and that's very, very difficult. Right now in the carpentry world, there is scopes of work like wood frame, like drywall, like interior finishes, flooring, finish carpentry, that there are no legitimate non-union contractors working at a certain level of construction above a certain amount. It's either you cheat or you're a union contractor. And the deltas, that's what it is. There's no legitimate non-union competition, because if you're a legitimate non-union contractor trying to do everything the way you're supposed to by law, you can't compete with the contractors that are doing it. And that's unfortunately what we're seeing.
Okay, thank you. And one of the goals of these hearings are to bring the carpenters and ironworkers together at the same table. This is
Right
It's been done before.
Yes,
I was here last time, and I was
You're
with the
always at our
woman from the
labor council
carpenters.
meeting.
Absolutely.
Yes, so I'm glad we can continue that work, and thank you very much.
Thank you so much, Council Weber. Council Mejia?
Yes, thank you. And so I really do appreciate the realness, right, in this conversation, because I really do believe, and everything that I do here is led by the people who are living the realities. Like, just to have y'all here today really means a lot in terms of how we move forward. So thank you, because your perspective is one that I don't have, because I'm not a laborer, right? I don't work in that space, but you do. And I think that the examples that you brought here today really help me, and also the people who are following this conversation, understand kind of the nuances of what's happening, especially around this whole idea that we're giving contracts to people who are not employing or giving opportunities to Boston residents. And there is where the problem lies for me. Because we built this city, well, y'all built the city. We're living in the city that y'all built, literally. But you know what I mean? Like, and then we're displacing a lot of people who grew up here in the city of Boston, right? They can't afford to live in the city that they're literally building. They're being, regardless of their status, regardless of what their race is, everyone is being exploited. Everyone is being taken advantage of when we're talking about this conversation right now, because it's the people who have the most that are getting away with shortchanging those who have the least. And I think that that's what this conversation really is about. And that accountability really has to have some teeth, because this whole building of the city of Boston, I know for a fact that there are folks who are making millions off the backs of the people who are doing the work. And because there is no real political will, a lot of people get away with it. And they do. And this is why, to Darlene's point, that we started this conversation. This has been going on for decades. And here we are, right? All the work that you guys have done, building the conversation, getting us to this point just to codify something into law really speaks to, like, the buck stops here. Because the city is also responsible for the neglect, because we're the ones who provide contracts to folks without doing our due diligence, right? So this accountability is all around. And so I don't have much to say, which is weird because I don't really have a lot to say about everything, but I think you all have said it all. And I just want to just acknowledge and thank you all for bringing your voice into the space. But while I have y'all real lived experience folks here, have you had a chance to look at the ordinance in terms of just, I know we're going to go into a working session and that's where we're going to get really deep in the weeds, but I'm curious, are there any things that you can think of that we haven't talked about here today that we should be keeping top of mind as we continue to navigate these conversations?
It was early on in the ordinance that I read, and I mentioned it earlier, the quote, like, studies have repeatedly shown that wage theft is concentrated among low-wage workers, women, minorities, non-citizens, and non-union workers. I mean, Local 7 specifically throughout the country, under our international, we have the most women in our local specifically. So you know that we're on the forefront of things like that. We cover all different races, nationalities, creeds, religions. We don't discriminate when it comes to bringing in members. That's for the whole Boston Building Trades, not just Local 7. I did want to have my little moment there to give us a pat on the back for the women. But throughout the whole Boston Building Trades, we promote diversity. I just feel that some of these other contractors that are getting on some of these public projects, like, really find out if they're meeting those numbers, you know? And then, of course, the Boston residents policy, too. Are they meeting those numbers if they're coming from necessarily out of city or maybe out of state? Because the BPDA process, too, I guess, lumps into this. It might not just be public processes. Mm-hmm. If there's private work, too. You know, Councilor Mahay, you mentioned the money that these people are making, whether they're from out of state or if they're close by. 9 times out of 10, they're in the suburbs. They're not in the city. You know, what they're putting into these buildings, like whether it be the building materials or the cheap stuff that they want to build with, because that's where that's where these cheaters are getting away with their profits. That's how they're running away with these profits. They're cheating the labor, the backs of the folks that are putting the building up, and then they're bad building materials. I mean, the carpenters see it a lot with the wood frame. Like, they're able to get away with it because they're putting in cheap building materials that are gonna then be put in by underfunded workers, and then they're gonna be able to still charge $4,000 a month for rent, or whatever it may be when they start to sell these units off, if it's housing or things of that nature. So, I mean, coming from an ironworkers background, I'd love to see everything steel, of course, because, you know, with the public housing and things of that nature, now I'm crossing paths into private public, but it's just a longer lasting product for the resident, the city person that's going to be there for the rest of their lives, if not a generational, you know, there might be a revolving door of people that come into the public housing realm and then leave the public housing realm, but the building will still be solidified for the next inhabitant, you know what I mean? And the Boston City resident deserves that. They deserve a long-standing building, so hopefully we're all dead and gone by the time we're rebuilding it again. And we're not having the conversation of, oh, I wish we did it then, you know. And that's another thing, you know, the building materials are huge for both, whether it's private or public. If they're going to build with cheap building materials, they're probably looking to undercut their workforce and the materials to make a profit.
Thank you, thank you. You gonna say something?
No, just reiterating, some points where you thought, maybe some extra language would be helpful, where it regards with TIFs, potentially adding apprenticeship requirements for certain municipal work, to be able to, hold contractors accountable to being able to provide those good jobs and careers for folks from the community. Again, we feel that construction is a little different than a lot of other sections when it comes to permitting and procurement and other things. So in some ordinances that we've helped work in the past, having its own section for construction, we felt there was a value to that as well.
Thank you. And, I'll end because I know we have a lot of other stuff to talk about today, but I feel like I have been here all day today, y'all. This is my second hearing. It's been a long day, and Coletta didn't get me, Zapata didn't get me coffee, so. But, I think one thing that I have learned is that I came into this council really adamant about racial equity and really fighting. And what I have come to learn in my short period of time here is that if we really start having real conversations about this work, that we realize that oftentimes we might be having the wrong conversation, because the people who are benefiting from the profits we should be talking about class also as it relates to these conversations. I know a lot of it is focusing on black and brown folks, and I'm always going to be the black and brown queen. Don't even get it twisted real quick. So just want to make clear for that record. But I will also say, especially when it comes to the work that I have been doing and I've been learning in the labor movement, is that a lot of these conversations are really rooted in class and access and information and wealth, right? Because those are folks who are getting richer off of all of our backs. And if you think about the labor movement back in the day, it was black and brown and white people, low-wage workers all working together to dismantle the system. And I think that sometimes we get lost in that conversation. And when we get lost, the people who win are the ones who are holding on to that power. And I think that that's why these conversations are really important as we're talking about developing laws and modifying ordinances, is that we want to make sure that the devil's in the detail and that we're really clear about who it is that we're going after and who we're holding accountable. And I think that is really, for me, one of the biggest lessons that I've learned in the labor conversation in particular, because I think that there are a lot of people who are making money, and it's not us.
Yes, yes.
Can I just say one last thing, because you mentioned political will, and I just want to be clear. Some of the frustration that comes out of me is not that there's not the political will here, city council, or with our mayor, past and present. There was political will. We got an executive order. Now we're codifying a piece of legislation that our mayor currently, in the past, was actually working on this very legislation with us. So I just want to, that continuity is really important to know in that history. Our level of frustration is that where there can be, it's been 10 years since we haven't been able to pass statewide legislation. So I just want to make it clear that there are levers that make every part of this contracting and subcontracting chain accountable and liable at the top. And that is actually what needs to happen. A change in our labor laws, because irresponsible businesses will continue to game the system, and then when we change the system, they're going to game it again.
That's right.
And so that's just to make profits off of our backs. So I just want to be clear that we are really thankful and glad to be here, and there's a level of frustration because our labor laws, both on the national level and on the state level, have not kept at the pace at which irresponsible businesses are gaming the system. So I'm going to leave you with that.
Thank you.
Thank you. Councilor Murphy's been so patient.
Oh, no worries. Thank you. One of the reasons, many reasons, but I ran for office and made sure is, that unions do have a seat at the table and they have a voice, and I would often tell the story of, all of the times people who never stepped foot in a classroom wanted to make changes to, teaching and all of that. And as a, BTU member, I'm like, where are our voices? Why aren't we asking the teachers and asking them directly what they think? So thank you, Frank, and I know you all said it in different ways when you said lean on our expertise, like reach out to us. And one of the questions, I had a list of questions I didn't ask the last panel, but when we go through the working session was, let's speak to the complaint process that the unions can provide. How can you support that process? So, and also I have the same frustration you were saying, Darlene, like we were saying earlier, why even let them? And it's wonderful that Trin and you worked on that, CM 16 wage theft form. As soon as we know that you've already had a violation, why are we allowing them? Because they're going to be the contractor that low bids. And what little fines or what little pushback we can give, we know is cost of doing business. They probably write it into the low bid, right? That we will figure out how to pay that if we do get caught. So how do we get ahead of that? We are smarter than that. Like we can put things, use our power here, but then also work on making sure it passes at the state and federal level too. But looking forward to making sure that all of you are always part of this conversation as we go forward and make this ordinance stronger. Thank you for saying it was there. It was an executive order. How do we tweak it? What do we add? But making sure that we are taking our time to make sure that when we're at the end of it and we all want to, pass this, that it's going to support our workers and help you, the work that you do as, union leaders, and how, in navigating the job sites where you're working alongside these contractors who are just undermining your workforce also. So looking forward to continuing to be here in this conversation. Thank you.
Thank you, Councilor Murphy. I don't have any questions, just want to express gratitude for you all for being here. It's about 5:05, so I know that some of you have been here since 2, so really and truly thank you. I think for me, this is really important that we empower workers, right, and we hold bad actors accountable. People deserve the wages that they've so fairly earned, and so codifying this is an important step. And so I really do take to heart everything that you all have said and the work that you've already done. Thank you, thank you, thank you, thank you. And just thinking about next steps, understanding, taking what Terry has said, and unfortunately she had to leave us, but establishing a clear legal authority and direction for governmental actors in addition to the database, in addition to some of the other creative things that have been proposed is really important. And I do look forward to that working session and really drilling into the details and having all of you present if you are able to be here. And just thank you. I think with that, of course, this is going to stay in committee. We'll have a working session in the next coming weeks. The schedule is getting pretty packed, so we'll try to squeeze it in ahead of November, even going out to December, but let's hope before then. But just want to double check that we don't have any additional public testimony. Okay? If it's okay with lead sponsors and folks here, we will adjourn this meeting. Thank you.